Hi guys! Hope everybody is having a great Saturday. And if you're wondering, yes, we're kind of just popping this live stream on. It wasn't really pre-planned. I think I scheduled it like 12 minutes ago. Living in Florida, there is more bad weather headed this way, coming through Tampa across the coast over to Brevard. So rearranging my schedule for the next 4 or 5 days in case we get an inevitable. There's like a slim chance we don't lose internet Wednesday if we get bad winds. So preparing my week for that. Yesterday we did a part 1 of YSL pretrial and largely focused on press statements from the Fulton County District Attorney Fani Willis, hearings involving requests for funding and broader power to prosecute gang-related crimes. And we walked all the way up to the time frame of the first bond hearing in the YSL trial. We closed the stream out. I was like, hey, I don't remember this being 9 hours long. Well, it's because there's other cases mixed in here that aren't part of YSL. So it'll be a bit shorter than 9 hours, thankfully. I have everything time-stamped to be efficient. I don't know if we'll get through all of it, though, because it is still about 5 hours worth of stuff relating to Shannon Stillwell, Deamonte Kendrick, and Jeffery Williams. Some of the other bond hearings, they're deferred to a later date. We also have the conflict of interest. The state wants to disqualify Brian Steele and Max Schardt because they represented other affiliates of YSL, alleged affiliates. And we'll hear a little bit of that as well in this same hearing. In the description of this video, there is Jeffery Williams, Brian Steele, and Keith Adams' response to the state's motion to disqualify. If you guys see Dublin Mug in the chat, thank Dublin Mug for that. He sent the document over by email. That is in the description there. And I think last housekeeping, yesterday we had Paul Hess say October 5th was his birthday, and then City Gent say October 6th. So because of time zones, and, I don't know if I'll be able to stream tomorrow, Paul Hess or City Gent, if you pop in here today, happy birthday. You guys say happy birthday. And, oh yeah, warning before we hit play. This is old. If you think the tech and the sound in present day is not the greatest, this has a lot of background noise. It's a fun time. So we'll get through it. We will get through it. I don't know why it's panned on the wall here. We'll get onto some faces in a minute here. But yeah, we're going to jump into it, and we're going to hear something today that, if we get to it, it's about 7 hours in. If you guys didn't watch the beginning of the trial, and I want to preface before we start watching, because yesterday somebody thought I laughed about the mall shooting that took the life of a young girl. When yesterday why I was laughing was the way Fani Willis said it, knowing that it was in retrospect. If I was in that moment, I wouldn't have realized it, but after watching the beginning of the trial, I don't know if you guys watched the first 2 weeks of trial, one of the first witnesses they called was a mall security guard. And they called him for the purpose of saying that Jeffery Williams, after hoverboarding through the mall with a friend, threatened to shoot this security officer in the face. So yesterday when I heard Fani Willis talk about how we need to make our malls safe to shop at during Christmas time, I laughed because in my head, I already saw the strategy play to conflate a really tragic issue, something that actually took place and took a life, to an alleged story involving a mall cop and Jeffery Williams. So my laugh was not about the tragedy. My laugh was about Fani Willis's district attorney, their play for this YSL indictment. So I don't know if we'll get to that today. It's 7 hours in. We'll see. And let me know in the chat, you guys, if you watched those first. I don't know if it was week 1. I think it was week 2. It was really early. But let me know if you remember the mall cop testifying. Hey, also to Steph, to Biff, Serena, Wendy. Good to see you guys. Biff says, when I'm talking, one of your cat lays down next to your phone. Here's the speaker. That's awesome. Hey to Mrs. Bennett. Hey, Dappy. Hey, Sky Mosaic. Great to see ya. We need you in here. The D Life's Jenny D. Hey, good to see ya. Chaz. And I love these cozier streams when we have a smaller chat because I can keep up with it. Factual Lie, good to see ya. Ms. Tooties. Michael Sanchez, good to see ya. Catherine Kells. Betsy says just when you're having streaming withdrawals, Kat makes an appearance. Yeah, because, you know, I want to make sure we get through some of this pretrial stuff while we have the court downtime. So we're going to try to work it in. Brittany Brown, same sentiment here, going through the YSL withdrawals. Oh, also pinned at the top of the chat is Nick Staro's panel stream from last night. Because of scheduling changes, he had a special guest, a very great guest, Stephen Gosney. Love, love, love Stephen Gosney. I wouldn't even be able to put the words together to give him his flowers enough. Extremely intelligent, huge advocate for the accused. Just really intelligent, great to listen to. That was a special guest on yesterday's stream. Nick had to rearrange the time frames a little bit, and it didn't work for me to jump on, but I was fine with it. I was happy to listen. Great, great panel show. So that's pinned at the top. Check that out. Bookmark it. Hey to Joni. Hey to Cars, Cats, and Aliens. Can we add a little slime to that? Yeah, and this is the point. So for those of us who haven't watched from the start, it's a great way to get caught up. Some really interesting stuff in retrospect. And let's see. Oh, not happy birthday to me, Michael. Not happy birthday to me. I mean, I'm sure we have others, but Paul Hess and City Gent, I know yesterday said they had birthdays this weekend. So, without any delay here, let's get into it. And I'm going to leave this on the screen. I love a good opportunity to leave Biff on the screen. So it's going to be loud when we start. I'll put it to half. We'll adjust it up. You guys let me know if I should lower myself or whatever. Here we go. Like a white noise machine.
Hi, good morning, counsel and interested parties. We're here on the record in the matter of the state of Georgia versus Deamonte Kendrick in 22 SC 182273. Good morning, Mr. Kendrick. All right. And good morning, Mr. Abt.
Good morning, Your Honor.
All right. Good morning, Mr. Geary and et al. Okay. All right. Okay, Mr. Abt, I believe that we reset you from the last calendar to determine or make a bond determination. Did I formally arraign your client at that point in time?
I don't know whether we formally arraigned him. Oh no, we did arraign him. We arraigned him at the last calendar.
Yeah, I believe that you asked me to waive formal arraignment, enter a plea of not guilty on behalf of your client, otherwise have 10 days to file motions upon the receipt of discovery. Is that correct?
That's correct, Your Honor.
Okay, all right. So today we're here for bond. So if you wish to go ahead and tell me the IL factors and the other things that I believe are necessary for me to make a bond determination.
Your Honor.
Now, remember, you just heard Glanville say Ayala factors. You know, that's a combination of things, right? Are you a flight risk? Do you have ties to the community? You know, what's the weight of, for example, the crimes you're charged with? Or are you a public safety concern if we let you on out of here? So there's different prongs that his attorney, Deamonte Kendrick, his attorney's going to have to argue. And you'll notice that it's Jay Abt. We saw him, he did opening statements, and we see him in the courtroom sometimes when Doug Weinstein's not there, but they are all co-counsel for Deamonte Kendrick, also known as Yak Gotti. So he's about to argue why Yak should be given bond, and not even a spoiler alert, we know that that doesn't happen, but you get to hear it.
To start, I think you should know my client is 29 years old. He completed high school. He is a full-time musician. He signed to a nationally recognized recording label. He's had 1 platinum and 2 gold records. Your Honor, he's got a child who is 7 years old, Dawson, who he helps to raise with that child's mother. He's lived in Atlanta his whole life, Your Honor. He has significant ties to the community. His mother, Tasha, is here. You'll just stand up, Tasha. And there are a lot of friends and family and people here from the community in support of him. If you'll hear on behalf of Mr. Kendrick, just please stand up. So, Your Honor, he's got a lot of community support.
Thank you, ladies and gentlemen. You can sit down.
He's got friends, family, business associates. He's really, I mean, other than for work to perform as a musician, hasn't really left the state of Georgia. He's got significant ties here. He's lived here his whole life. And there are, and Your Honor, if there's a way that I can display these to the court, or I can just enter them, if we're doing this, I assume we're doing bonds proper today. So,
do you have, Mr. Geary, do you have any objections to what have you seen what Mr. Abt is going to show me?
Now, this is Don Geary. If you tuned in late, you didn't know who he was, because he done left.
No objections.
Okay, all right. And you can just hand them to me if you have a copy for me.
I do, Your Honor. And
Okay,
so,
all right.
what I'm, and if Your Honor is okay, I'll just
I'll
collect.
admit your, okay, so we have 1, 2, 3, 4, 5, 6, 7, 8, 9 photos. I'll admit them as D1 for purposes of the motion, okay?
Thank you, Your Honor.
All right.
And so what you're looking at are photographs of my client in various philanthropic and community service organizations. He helped create a youth football team to help inner city youth stay off the streets. That is known as the Atlanta Trackhawks. He helped found that organization. He coached those kids. He created this youth football league, which is actively involved in order to ensure that young inner city children are doing the right thing, learning the right ways in life, and having an outlet. He also is involved in a other charity called Area 51, which there is photographed evidence of, where he helped raise money for and provide food for underprivileged and inner city families and homeless people. Your Honor, you'll also see in those photographs, there are charity concerts my client has done in order to raise money, where he took all the proceeds of those concerts and used those funds to provide the food and football equipment and other means by which he supported the community. Now, I expect Mr. Gary to raise that my client's had some criminal history, and we don't deny that. But I think what's telling about his prior criminal cases is that he has shown up and appeared for every single court date, every time, both in state and federal courts, when he was charged with crimes that could have cost him his life. He does not have failure to appears. He is not a flight risk. And I would present to the court, he had even another murder case in this very courthouse in which the state declined to prosecute him, and he showed up for every court date. The state has a habit of wrongfully accusing my client of these serious crimes. And they're going to try and argue that he's been arrested previously for other crimes, several of which he was not convicted of. But he's got community support, Your Honor, as I'm sure Your Honor would expect in a serious case like this. We'd be happy to have him on house arrest and have an ankle monitor on him and provide the state and the court with a list of approved visitors, which the state could have the option to edit and change. And the only reason we really want him to leave the house is for a medical emergency. I can go to his residence and he can assist me in his defense, or I can meet with him by Zoom. But I do believe that the court should consider a reasonable bond in this matter. He does have ties to communities. He's not a flight risk. We'd be happy to turn over his passport. And I think we are humble before the court in asking that the court issue a bond, cash property or surety good bond of $100,000. Thank you, Your Honor.
All right, thank you, Mr. Abt. Mr. Gary?
Good morning, sir.
Good morning.
Judge, I'm not going to belabor the record that the counsel went over. It is extensive. I will say in one of the incidences in a federal court, which you'll hear more about probably later in the hearing today, Mr. Steele actually represented Mr. Kendrick in a probation revocation in federal court. So apparently he doesn't do very well on probation. For the court's knowledge, and I guess I'll start and go a little backwards, while Mr. Kendrick has been in court, we have been documented to using another inmate's phone messages, or phone codes, to use the phone at the jail to try not to be discovered in some of the phone calls that we had concerning Mr. Kendrick. He's actually trying to get a phone brought to him in the jail, and we actually are aware right now that he actually has a phone in the jail, or had recently. He may not have it right now, that he's been using that cell phone at the jail. So he's not working very well now. At the time of his arrest from the indictment, he actually fled the house. He was stopped back in the woods, so he tried to flee then. He has 10 new open charges as a result of that arrest. My understanding, he's on no bond from that already. And that's just on the recent things, Judge. Judge, he has a murder charge in Acts 17, 18, and 19 of the indictment that's pending in this case. He's also been, and that's again a murder charge of Mr. Donovan Thomas. Judge, he's also been convicted in Act 56, which is a conspiracy to commit murder, to which he actually confessed to, and he and another individual on this indictment were found with a fully loaded AK-47 and a .40 caliber handgun. They just happened to make a traffic violation before they got to where they were going, and they were stopped by police and the weapons were located. Judge, he has been active throughout the pendency of this gang. He is active now, continues to be active. When we've got him on the phone, the cell phone from the jail, he is continually speaking about gang activity to the extent that he's even trying to hide evidence. There were cell phones located at a particular area, and he called to make sure those phones were disposed of. Given that we were on that call, we located those phones before they could be destroyed. So the attempt was made. We just happened to be lucky enough to be one step ahead of him in that situation. He's got a prior, to my understanding, in the attempted murder case also of a gang charge, so that's documented as well. In the conspiracy to commit murder charge, they also had a stolen weapon, which is very common with this outfit. They have numerous stolen weapon allegations throughout this. They don't use weapons that respectively are traceable back to any of them. During that time, he was a convicted felon, so he's got also a conviction for possession of firearm by a convicted felon. So he clearly doesn't listen to court's instructions as given to him. He is in a music video, and I know we've had some back and forth on that, but that's as late as 2020, where he basically said that if people mess with one of the other gang members, they're going to die. In 2020, he also, and I think we've spoken to this before.
I can't get over, like, why are we just staring at this part of the wall? Like, why?
He saw YFN Lucci in a mall in the Atlanta area, went out and was photographed standing on top of his car, and that was released on social media to antagonize a rival gang. And that was that was 8/11 of 2020. We've got other numerous videos and photographs in the indictment showing the defendant posing for these things and involved in these things, demonstrating a allegiance and a loyalty to the gang and the gang activity, to including violence and other types of gang activity. Given that, I would say that he is a pending murder, that he's already pled to an attempted murder, that his conduct has showed complete disrespect to the court's orders prior to having a weapon by a convicted felon, and while in jail, attempting to circumvent the jail call process and to get a cell phone in, which he was successful in doing, and talking about destroying evidence in there while doing that. Your Honor, I would say he is an extreme threat to the community, to witnesses, and to commit additional felonies, and ask the court to deny bond.
Your Honor, may I briefly respond?
You can, sir, go ahead.
So the first thing I'd like to address is Mr. Gary categorizes my client as having been previously convicted of and pled guilty to allegations in this indictment, which is, I don't know whether Mr. Gary is just having a...
That's the predicate, I think, or that's the allegation as part of the indictment in one of the counts. I think that's what he's referring to.
Your Honor, he has not pled guilty to any underlying... He's been convicted of one federal gun offense and has a probation violation from that offense. Those are his convictions. So if the state wants to allege that that is the basis for their charge that he's a convicted felon in possession of a firearm, they're allowed to do that. But to say that he's been already pled guilty to and convicted of counts in this indictment is a gross misstatement. And Your Honor obviously knows that my client's presumed innocent. That's the presumption he carries with him at this very hearing. The state wants to allege that he fled the home. At the time of his arrest, he was a visitor at a friend's home. He was a co-defendant in this case. And there were an army of people approaching through multiple directions towards the house. And at that moment, at that particular moment, he did not know that there were police, that they were police, and that they were there to arrest him. All he knew is there were armed men approaching the house. And so, yes, he ran for his own safety. Once he realized they were police, he returned and he was arrested. There is a photograph of my client standing on a car. That's about the best evidence the state has. Hard evidence they have against him. That's not a crime. And I think the other thing that Mr. Gary brings up and the court should consider, because it's part of 17-6-1, is the economic impact. Not just to my client, but this case in general. The court, in its discretion, under that code section, is allowed to consider a wide variety of factors. And what the government is doing here, in this case, is sending a message to the music industry and the entertainment industry in Atlanta that is going to have a massive chilling effect. Atlanta has become, over the last several decades, a hub in the United States for the music industry, for the entertainment industry, and it's created a tremendous amount of jobs and income and opportunity for young inner city youth. I would argue to this court it's actually prevented a lot of crime. And what the message that the district attorney's office is sending to our community and to our country is that you better not come to Atlanta and make rap videos, because we're going to use those against you in court. And we're going to create a chilling effect on the First Amendment. And we're going to push out this tremendous, beneficial, economic wave that has blessed our city and blessed our community. They're sending a message to every young kid today in the city who hopes to grow up and become a successful musician, that whatever you go on YouTube and the internet and create as your art form, you're gonna have that used against you later. And that is a shame on them. That is one of the greatest things that has blessed our city and our community and our state in the last 2 decades. And Your Honor should consider that in granting my client a bond, a reasonable bond. Thank you.
So it might seem like why are we arguing about free speech? But like the evidence that they try to hold Yak with is really mostly his lyrics. And also at the same time, this is June of 2022. This is when the appeal was still in process. I forget something with a B. What was that the Georgia Supreme Court case? It wasn't really just the lyrics. It was an issue of showing a video without the lyrics or the other way around. But that was pending appeal. Those oral arguments were taking place around the same time. So in my opinion, it was important for them, for the record, to be making these First Amendment arguments. Because if you're going to deny someone bond, saying that there's compelling evidence against them, but that compelling evidence could be a free speech issue. And then your other evidence is, possession. So, for me, it's just for the record. It just seems kind of like more of like a monologue or advocacy for free speech. What does this really have to do with the bond? But it's because so much of this case is built around lyrics and music, and YSL as a record label also being a gang. Oh, okay, there you go. There you go. And also, I don't know, let me keep playing for a second to see if Don Gary says anything else important. There's a bit of a lull that comes up, so let's see.
All right, thank you very much, Mr. Abt. All right, counsels, based upon the proffers that have been made at this point in time, I do believe that Mr. Kendrick is a threat to witnesses and likely to commit other crimes and a risk of flight. For those reasons, I'm going to deny bond at this point in time. Mr. Kendrick, since I've denied your bond, though, the earliest trial date that I have at this point in time, where I've set the other persons under this indictment, is the 9th of January of 2023. So Mr. Abt will talk with you a little bit more about that. And Mr. Abt, if you should file any other additional motions to represent your client, if you would be so kind as to send copies of those to Mr. Chamberlain and Mr. Kearns, the court staff attorney, as well as the court, since we're not an e-file party, okay?
Of course, Your Honor.
All right, okay. Unless you have any other business, sir, you may be excused. All right,
Thank you so much.
All right, thank you, sir.
Man, I don't want to skip anything. I think the next one is still a YSL co-defendant, but they ask for more time. So let's just play through it so I don't skip it. There are other cases that have nothing to do with YSL on the docket for the same day, but let's be sure.
Yeah, Christina, here you go. Application reinstatement. Christina, you ready? Number five. Yeah.
Oh yeah, when you get a
All right,
chance,
Mr.
check out Christina
Jones, we're
Weaver's
going to
hairline.
take care of your revocation matter at this point in time, so just bear with us a second. All right, this is the state of Georgia versus Jaquan Emmanuel Jones in 18 SC 163169.
Okay, so this is, they're dealing with another matter totally unrelated to YSL. Okay. So then our next timestamp is a ways away. So 2:42. Now we're going to start to hear a little bit from Schardt, and then we're going to get into conflict of interest issues.
Yeah, get the physical notes. No.
Hey, Nick.
All right, good morning, councils, interested parties. We're here on the record in a couple of matters. The first one being the state of Georgia versus Shannon Stillwell in indictment 22 SC 182273. Here for state's notice of conflict with defense counsel and arraignment and bond. Mr. Schardt, good morning, sir.
Good morning, Judge.
Okay, all right. I see you've been relegated to the cheap seats, and the fact that Mr. Steele and his entourage have taken up their seats. Would you like for us to provide you a seat?
I'm
Or are you good right there?
I'm fine here.
Okay, all right, okay, no problem. All right, so I just don't want you to feel you were left out. All right, and then the other position is the state of Georgia versus Jeffery Williams, 22 SC 182273. Good morning, Mr. Steele, and good morning, Mr. Adams. And
Good morning, Judge.
all right, and we are here for on the state's motion to disqualify defense counsel and for arraignment and bond. Is that correct? All right.
Yes, sir.
Okay, all right. All right, let me first to make sure that I have the aforementioned. Is there anybody else I was missing? So I just want to make sure I have. Mr. Williams, can you, all right, I'm going to mute you at this point in time, but we got you. All right, and then Mr. Stillwell? All right, sir, I see you on the platform. Thank you, sir. Okay, who is in S214? Violetta, can you unmute S214, please? All right, sir, in S214, what's your name?
Scott.
I'm sorry, one more time?
My name's Scott.
Maybe Mr. Ratloff's client, Judge. I think that's how they resolve.
Mr. Scott, we resolved your matter. You're free to go.
So maybe I understand what's going on.
Say again?
I was sitting back to get an understanding of what's going on.
He can't do that today. He said he's gonna come out and see you, okay?
Who?
Mr. Ralph Hoff. Okay? He's gonna come out and see you, but at this point, I'm gonna excuse you for the day, okay? Thank you, sir.
Mr. Glenville, I think mine got unmuted again.
I'm gonna keep you on mute because I can't compete with the background noise from your location. So I'm gonna unmute you, okay? If we need to talk with you, we'll go ahead and unmute you, all right?
Yes.
All right, no problem. All right, before we go ahead and get started, folks, I've had the opportunity to read both the state's motions as it pertains to Mr. Schardt and Mr. Steele. And I've also had a chance to take a look at the responses that were filed on behalf of Mr. Steele as well as Mr. Schardt. And stated you can take it any way you want, but I think that the court, if I can frame just generally your issue in this particular circumstance for the state, and maybe the defendant's position on it. For, as it pertains to Mr. Steele, you were saying that there's a violation or there's a potential violation of 3.7, which is lawyer as witness?
Your Honor, we're withdrawing the 3.7 claim today.
Okay.
And Mr. Geary is going to explain
Judge,
that.
I'd like to explain that to the court.
Okay, all right, well, go ahead.
Quickly. We have notified Mr. Steele that I personally interviewed the officer previous to us making the claim, and the claim seemed solid. As we further investigated concerning the hearing today, it became evident that the officer truly believed the statement that Mr. Steele, quote unquote, confessed. However, the rendition of what the officer went through, we don't think that legally qualifies, and we're not going to support that in this motion, and we're withdrawing that in this motion.
Okay.
The officer did speak with Mr. Steele, but the interpretation of what occurred is different, and we're coming in on the side that there was no confession given the completion of our investigation of that matter.
All right, so you're satisfied?
So, if you want, we can take a quick look at that. If not, you can see Steele's opposition argument to this initial issue in the description. My main question, the main thing on my mind is, this is Don Geary. This is before Don Geary left the DA's office. If this had been Prosecutor Love, I do not think they would have made the decision like, hey, you know, we kind of looked at it ourselves and decided, you know, there really wasn't merit there, so we're not arguing that anymore. We're not arguing this issue. But we can look at it if you guys want to get the specifics. Let me see. We can jump right to the paragraph. And this, again, this is from Dublin Mug, who just sent this document over, I think it was yesterday. But it's also in the description. Let's see. So real quick here as a brief summary so we can get back to the hearing itself. The state... The state urges this court to disqualify Mr. Steele on two general theories. First, that Mr. Steele's alleged involvement with Mr. Arnold, Martinez Arnold's pre-arrest supposed, quote, confession, renders him a necessary witness for the state and thereby disqualifies him from representing any party under Rule 3.7, which says, in Mr. Arnold's case, there was never any, quote, confession made through Mr. Steele to the police. So we just heard Don Geary say, look, the officer represented that it was his belief that, you know, Arnold made this confession through Mr. Steele and that the officer interpreted Mr. Steele's words as a confession. And here the footnote continues, this allegation is totally belied by the record. The state wrongly misleads this honorable court by claiming otherwise as shown. So here we have the defense, this is Steele and Adams writing this, saying that the state is misleading the court, this honorable court. And we have Don Geary come up there and be like, you know what, actually, we're not going to pursue this. Now that we think about it. We agree. We concur. We agree with this argument here. So that's really what they were talking about here. And again, Martinez Arnold, that is the client of Ashley Merchant. I anticipate that he will be called in the near future in the YSL trial. The terms of his plea agreement are a bit stronger than some of the others we've seen. He does not need to testify that YSL is a gang. So there's that. There is that. But what do you think? Would Love have gotten in here and made the same decision here? I just can't picture it. Cannot picture it. And big thank you, my friend Nick Starro. Again, great panel show, Nick. I don't know if you were here in the beginning. I loved it. I was so excited to start this stream and talk about Steve Gosney being the surprise guest since I couldn't say it yesterday. I didn't know until you told me right before, and it was a secret, but I didn't know until last minute. It was a wonderful, wonderful panel last night. I am tempted to watch it on replay. So guys, pinned in the top of this chat, and I'm going to add it to the description if you're on replay crew, Nick Starro's Friday panel that was a little bit late for good reason yesterday because Stephen Gosney was guesting. Super, super awesome. Thank you so much for the 5 gifts, Nick. Very generous. Make sure you guys say thank you. And actually, I'm not sure of the lady's name. I also see the chat asking. I'm not exactly sure of her name. We'll have to listen for it. And I know sometimes we're going, geez. You can watch this video in full on YouTube if you want. Like, holy moly. Hold your horses, people. But yeah, we'll have to listen for her name here and see if we get it, because I'm not sure.
But you will not otherwise
He's off our witness list.
require Mr. Steele to be to testify or be part of any foundation that.
Correct, sir.
Okay, all right. Mr. Steele, any objection to that? They're going to withdraw that particular issue as it pertains to as it pertains to lawyer's witness 3.7.
No, Your Honor.
Okay, all right. Madam, I apologize. Your name? I apologize.
Lizzie Rosenwasser.
Ms. Rosenwasser, I can't tell, I see you without your mask, so,
here we go.
without, okay, now I see. Okay, all right, thank you, madam. All right, all right, and Mr. Smith, again, good morning, but I have all 3 of you now, okay? Okay. All right, so that having been settled, that issue, at least as it pertains to Mr. Steele, the 3.7 issue's been withdrawn. You still have 1.7 and 1.9, and I guess you're going to make argument on that particular issue, and to that effect, is that correct, madam?
Yes, Your Honor.
As well as, is that the same basis that you're moving to disqualify Mr. Schardt?
Your Honor, to clarify for the record, we are only moving to disqualify Mr. Steele. What we filed for Mr. Schardt was a notice of conflict. We believe that all of Mr. Schart's conflicts could be waived. We are asking today, and I do plan to go into this further in my motions for both motions, we are going to be asking today to have all the affected parties, if they wish to, come in and waive those conflicts on the record. While we do appreciate the written waivers that Mr. Steele has submitted, we believe that to ensure that the record in this trial is perfect and has no grounds for appeal. And I will go into this further in the motions because we do still believe that Mr. Steele is conflicted. However, we believe that although Mr. Schardt currently has a conflict, that conflict could be waivable. So at this point, we would ask the court to inquire into that conflict because we do believe that Mr. Schart's conflict, as it only affects a former client, may be a waivable conflict. At this point, a conflict exists, but that conflict could be waived under 1.7b, whereas we do not believe that Mr. Steele's conflicts are all waivable.
Okay, all right. All right, well, given that, then.
And the short for, because we've talked a little bit about Steele's conflict of interest with Blaylock, but with Schardt, if that's new to you, that's because Schardt has previously represented Christian Eppinger in different matters.
Madam, I'll go ahead and let you proceed, and then I'll let Mr. Steele respond if he should so desire, because it appears that looking at 1.7, and that reads as follows: a lawyer shall not represent or continue to represent a client if there's significant risk that the lawyer's own interest or the lawyer's duties to another client, former client, or third person will materially and adversely affect the representation of the client, except as permitted in Rule 1.7b. And give me 1 second. and also the court's had an opportunity to kind of take a look at the case law of the state as well as the defenses raised in this particular situation. And I've had a chance to take a look at particularly Benucci Height, that's H-E-I-D-T versus the state, Wheat versus U.S. And it appears that what brings us here is that Mr. Steele under 1.7 has already kind of, because he's the lawyer that's representing his current client, has already made that determination that he can represent his client. But it appears that the case law then shifts to a couple of things and says that that either the court can inquire about a conflict, given that this is a criminal case with multiple clients, multiple defendants with multiple counts on its own motion. But if you are, the state is moving, or the other party is moving to disqualify him, that there has to be a violation of one of the violations under the rules of professional responsibility, and there should be some proof to that, or at least some particular Bernocchi, and that is B-R-N-O-C-C-H-I versus Fortucci, and that's F-O-R-C-U-C-C-I 279.
Sorry, I didn't mean to click there. So there is a part in this stream, and I'm so nervous that I'm gonna forget to stop it before it starts. But they had lost signal. They lost the feed, and it does like this emergency beep. Okay, we have some time before we get there. Sorry if I get us a little bit before where we were.
Bernocchi, and that is B-R-N-O-C-C-H-I versus Fortucci, and that's F-O-R-C-U-C-C-I 279 Georgia 460. It appears that in looking at Bernocchi, that Comment 15 to Rule 15, Rule 1.7 places the primary responsibility for resolving conflicts of interest on the lawyer undertaking representation. That would be Mr. Steele. A court may raise the question when in litigation there is reason to infer the lawyer has either neglected responsibility, and imposing counsel may raise the issue where the conflict is such as to clearly call into question the fair or efficient administration of justice. And then, of course, the case law directs that to advise an objection from opposing counsel should be viewed with caution, and it can be used as a technique as harassment. So in order for you to have standing, which is one of the things Mr. Steele is raised, is that the lawyer having the conflict of interest simultaneously representing multiple defendants, which would in this case be formal representation. There must be a violation of the rules which is sufficient to serve to call into question the fair and efficient administration of justice. And then it goes on to say the Supreme Court, our Supreme Court has adopted or kind of mentioned what Texas does in Henry Robinson, where opposing counsel must provide substantiation. So I'm going to need to probably hear something on that. So from looking at Bernocchi, I can raise the issue on my own, which I would have given what you said already. But what Mr. Steele is saying is that the burden is upon you, since he's already made this decision. He can potentially represent Mr. Williams in particular. So we'll start out with him to begin with, and then you can move on to Mr. Schardt, okay?
Okay, yes.
Okay, all right.
Your Honor, so our purpose today in raising this motion, first of all, and I do recognize the court's notice of the law saying that these motions can be used for harassment. That's not our purpose today. Our purpose today is to ensure that each of the defendants named in this indictment, and that includes Mr. Williams, but also Mr. Blaylock, Mr. Stillwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, all present or former clients of Mr. Steele, also have their rights properly preserved. So
Now, this is really important, right? It's not just a complete farce for the prosecution to be concerned about a conflict of interest. Why? One, ethically, I mean, you shouldn't want somebody to be prosecuted and only be represented by an attorney who's not looking out for their best interest and has a conflict that hasn't been waived, whatever the case may be. But second, even if as a prosecutor, you just want a win and you want your win to stick, a conflict of interest could be an appeal argument. So, and you know who argues this? You know who makes these types of arguments? Ashley Merchant. So if you want to prevent the inevitable argument on appeal from somebody like Ashley Merchant saying, look, there was a conflict of interest. You've got to make sure you make these arguments when the time arises.
One of our main concerns here is that none of these waivers are on the record. We would ask, even if this court were to deny our motion to disqualify Mr. Steele, that each of these waivers be made on the record. Right now, they're written, but we believe that in order to ensure that everything is proper on the record and that we're able to create a perfect record in this case, that those defendants be brought here and their waivers be placed on the record. That's out of Taylor versus State. That's 320 Georgia Court of Appeals, 595. That's a 2013 case. In that case, defendants alleged on appeal that there had been a conflict in the lawyer, and as a result, they should get a new trial. However, because the waivers were actually made on the record by the affected defendants, as opposed they were taken in court, made on the record, the Court of Appeals found that any error was induced by the defendant's statements, and that as a result, the case was not reversible. So first of all, more than anything, we would ask that any waivers be made on the record, as opposed to simply the written waivers, which again, while we do appreciate, we believe are not sufficient to waive the conflicts, especially in light of our allegation that Mr. Williams operates a position of leadership in the gang. That's in count 56 of our indictment. We do allege that. Our concern is that as a leader of the gang, perhaps some of these individuals may feel influenced. So we would like them to be advised by this court on the record, and if they still wish to waive their rights, we believe that would at least cure some of these potential conflicts. However, Your Honor, our main concern, and I did hear the court cite to Bernucci, but our main concern is not with Mr. Steele's former representation of various clients. While we do have concerns about that, our main concern lies with Mr. Steele's current representation of co-defendant Blaylock. Mr. Steele is currently representing co-defendant Blaylock in Mr. Blaylock's direct appeal of his murder convictions. Mr. Blaylock was previously convicted of murder, a murder that occurred in 2019. That murder has then been alleged as one of the predicate RICO acts. So in this particular indictment, the murder for which Mr. Steele is presently representing Mr. Blaylock on appeal, that murder is also one of the counts alleged in this indictment.
That apparently, that case has that been returned from the court, from the appellate court already?
No, Your Honor.
Okay,
So
right.
the posture of that case right now is that Mr. Steele has filed an entry of appearance. We are awaiting, and I'll be handling that appeal as well. We are awaiting transcripts and a motion for a new trial. There is a scheduling order on that case. I believe the hearing is set for either late this year or next year. But that is at the motion for a new trial stage and the Superior Court stage. So he's currently representing Mr. Blaylock. And I'll notice that in his motion, Mr. Steele alleged that he has not spoken to Mr. Blaylock. However, I would like to advise the court that although Mr. Steele perhaps alleges that he has not received any information about this, the federal court, so the 11th Circuit, employ an irrebuttable presumption of the disclosure of relevant confidential information when an attorney represents someone on a related proceeding. And that is out of United States versus Cordoba. That's a 2013 district court case.
Can you spell Cordoba for us, please?
C as in cow, O, R, D as in dog, O, B as in boy, A. That's a 2013 district court case out of the Southern District of Florida. But it is citing to United States versus Henry, which is 307 Fed APPX 331, and that's out of the 11th Circuit, and that's 2009. And specifically, the rule is that there is an irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. Further, that court found once it is shown that the prior representation was substantially related to the current representation, then it is irrebutably presumed that that relevant confidential information was disclosed. And further, an attorney's representations that he cannot recall any confidential information that would be useful in the cross-examination of a potential client does not alleviate the potential conflict because the situation might change. So I think that's particularly pertinent in regards to Mr. Steele's representation of Mr. Blaylock. And I would also like to point the court to Georgia case law, specifically the Height case that the court mentions, the 2013 case out of Georgia. And particularly the showing required, and this is also reflected in 11th Circuit precedent for pretrial matters, there is no requirement of an actual conflict, but instead, and this is from Height at 346, Accordingly, the courts must recognize a presumption in favor of an accused counsel of choice, but that presumption may be overcome not only by a demonstration of actual conflict of interest, but by a showing of a serious potential conflict. So the key language in this case, and in a lot of the cases out of the 11th Circuit and out of Georgia, is the existence of the serious potential for a conflict.
What's the potential conflict? That
So the potential conflict here is similar to that which is articulated in Height, which is if we would like to come to Mr. Blaylock, and we anticipate, and I'm putting this on the record now, if defendants in this indictment wish to cooperate with the prosecution and provide testimony against other defendants in that indictment, we are willing to offer deals depending on the information and depending on the defendant. We, at this point, would be unable to offer Mr. Blaylock any such deal because the representation of Mr. Williams would be a conflict. So I would like to point the court to Height at 347. Specifically in that case, the court found that because the prospects of the conflicted attorney advising the co-defendant about any deal that might be proposed by the state to secure her testimony against Height or cross-examining her on behalf of Height were rife with serious ethical problems. The trial court did not abuse its discretion when it determined that the conflicted attorney's representation of both the co-defendant who had previously been indicted with the defendant would materially and adversely affect his representation of the main defendant. Additionally, Mr. Steele actually cites to Lewis versus State as well in his brief. In this case, is very different from Lewis, but Lewis, which actually found that disqualification was improper because there was not basically the conflicted firm did not actually possess information about the witness, but Lewis even recognized the serious potential of conflict rule. In Lewis, the court recognized that there was a risk, but in Lewis there was not a significant risk. Here, however, there is a significant risk, and federal court has similar laws like this. So in another case that's out of the Southern District of Florida, which again is 11th Circuit, and I just point to it because it's pretty analogous to our case, it's called United States versus Gutierrez, Gutierrez, and that's 2010 out of the Southern District of Florida.
Do you have another citation or fits?
Yes, Your Honor. The one I have is Lexus, so I hope that's sufficient. It's 2010 United States District Court, Lexus 99424, but it does cite to law that will hopefully be that is out of the 5th Circuit, which of course became the 11th Circuit. And specifically, the court found that an attorney cannot advise. So in Gutierrez, there was.
Spell Gutierrez for us again for
yes, Your Honor.
myself and for Ms. Weaver.
Yes, Your Honor. G-U-T as in tie, I-E-R-R-E-Z.
Thank you, ma'am.
Now, in Gutierrez, there was an attorney, and he previously represented the cousin of a defendant. But the cousin of the defendant and the defendant were targeted in the same federal investigation. Although the attorney never officially represented the cousin did hold that attorney out to be his attorney. For instance, he gave business cards of that attorney to federal investigators. But essentially, that's actually less representation than what we have here with Mr. Steele and Mr. Blaylock. Mr. Williams and Mr. Blaylock by Mr. Steele. And specifically, the court in Gutierrez found that there was a conflict here. And first of all, the court noted that citing to Wheat, for a court to find a potential conflict of interest, both clients do not need to be charged in the same indictment or subject to trial in the same proceeding. Further, and this was citing to the Wheat case that the court mentioned earlier in this hearing. So further, the court in Gutierrez again mentioned that irrebuttable presumption of disclosure of confidential information wherever there is an attorney-client relationship, and that once it is shown that the prior representation was substantially related to the current representation, then it is irrebuttably presumed that relevant confidential information was disclosed. Now, specifically, the court found that there was a serious potential for conflict here, finding that this attorney should be conflicted because, and this is quoting the court at page 14 of that opinion, moreover, Mr. Mitchell, the conflicted attorney, cannot adequately advise either of the defendant or his cousin about their option to cooperate against the other. And that's citing to Baty, B-A-T-Y, versus Balcom, B-A-L-K-C-O-M, 661 F3D 391. That's a 5th Circuit case, 1981. Of course, that later became 11th Circuit precedent. And specifically taking the quote from the Baty versus Balcom case is the conflict of interest before trial alone would be sufficient to grant that motion, because had the attorney not been facing a conflict of interest, the attorney might have been able to negotiate a plea agreement on one defendant's behalf in return for becoming a prosecution witness against the other defendant. And I also want to point to another quote out of that case, which I think is relevant for this hearing. And this quote is, "The court may refuse to accept the waiver," such as what we have here between, there is of course a written waiver on the record for Mr. Blaylock. "The court may refuse to accept the waiver where necessary to ensure the adequacy of the defendant's representation, to protect the integrity of the court, and to preserve the trial court's interest to be free from future attacks over the adequacy of the waiver and the fairness of the trial." And that's citing to U.S. versus Almeida, ALMEIDA 341 F3D 1318, and that's 11th Circuit Court of Appeals 2003. So here we would argue that it's very similar. In this case, we believe that especially Mr. Steele's, and to some extent his representation of his former clients, however, we believe a waiver on the record may be able to cure those conflicts. However, we would of course have concerns that even with those former clients on related proceedings, should they choose to testify against Mr. Williams or anyone else, Mr. Steele might be conflicted in his ability to cross-examine those former clients. But particularly,
The court had a question in terms of, like, several of these clients, Arnold, Greer, and Blaylock, all have predicate offenses. Like Arnold is Act 11, Count 1. Greer is Act 108 of Count 11, and Blaylock is Acts 74 to 76 of Count 1. Wouldn't that be a potential issue if I'm looking at potentially a resolution or some other issue related to this case? Wouldn't that pose a potential or an actual conflict?
yes, Your Honor, it absolutely does, and that's the next part of my argument, because I just wanted to start with Blaylock because our biggest concern is that he is currently representing Mr. Blaylock. He is Mr. Blaylock's attorney of record. Mr. Blaylock, although he signed a waiver through another attorney, Mr. Blaylock is actually unrepresented in this case, and the only representation that Mr. Blaylock even has right now is Mr. Steele on his appeal. And as the court, I'm sure, is aware, sometimes with these appeals, we can work things out, especially if there is a pending case. I'm not saying we definitely will. It would have to be if Mr. Blaylock were to say, hey, we'd like to cooperate, but he can't even do that because of this conflict. And so that's why we started with Mr. Blaylock. I would also like to advise the court in terms of these present conflicts that we're discussing. Mr. Steele is also currently the counsel of record for Mr. Quantavious Greer in case number 10 SC 92020. And we certainly appreciate Mr. Steele bringing this to the court and the state's attention. As I noted in our original motion, we were trying to file that as soon as we could to make sure that, save Mr. Steele from any if disqualification is warranted, which we believe it is. We wanted to get that out there as soon as possible to avoid any kind of gamesmanship. But as soon as we learned about that representation of Mr. Greer, we did look into that. And we noted that Mr. Greer is actually, he was convicted of murder. That case was reversed. The state will be trying that case again. That case is presently before this court in a separate case. That case is not related to the present indictment, but Mr. Steele is still Mr. Greer's counsel of record. Should Mr. Greer wish to cooperate, perhaps negotiate some sort of resolution to both of his cases, that would certainly create what is very obviously the serious potential for conflict that I've described. So that's another one. Also, as the court just raised to me moments ago, we do think that there are serious problems with the former clients based on especially the federal case law that I've discussed, where there is this irrebuttable presumption of disclosure of confidential information whenever there is an attorney-client relationship. And when that issue is substantially related to the current representation, which obviously it is, these counts are the predicate acts for the present case. We think that there is an irrebuttable presumption that relevant confidential information was disclosed. So, and again, also I'd like to point the court's attention to another case out of Georgia, the Georgia Court of Appeals case, Edwards versus State, 336, Georgia Court of Appeals 595, parallel site 784 SE 2D 924. That's a 2016 case. And in that case, the defendant's attorney had formerly represented the victim's mother in a previous proceeding. It was a child molestation case that was on trial. The court found that there was a serious potential for conflict there. And although the defendant in that case waived the conflict, the Court of Appeals found that the trial court properly declined to accept that waiver because the defendant's waiver of his attorney's conflict of interest does not always cure the problem, because courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. And that waiver does not work, and this goes to one of the non-waivable conflicts in 1.7c. Waiver doesn't work because his defense counsel's loyalties would have been divided by the above stated ethical duties. And again, the reason that the state is bringing these motions today and why we are so concerned is because, as the court found in Edwards, in the absence of an effective waiver of the right to conflict-free representation, and so that would include cases where conflicts cannot be waived, allowing the trial court to proceed to verdict would have created a serious potential for error sufficient to allow Edwards to obtain reversal of any guilty verdict by claiming on appeal that he was prejudiced by the conflict. So essentially here, Your Honor, to sum up my argument, basically, first of all, while we appreciate the written waivers, we believe that if the court is even willing to consider waivers to cure any of these conflicts, those waivers would need to be here in person on the record, where the defendant could confirm to this court, and this court could observe that defendant, you know, everything around him, his demeanor. He couldn't come back and say, that's not my signature, I didn't authorize this, anything like that. We'd ask that these be on the record, where the defendant advises that he has had the consultation, he has received in writing reasonable and adequate information about the material risk and available alternatives, and he's had the opportunity to consult with independent counsel, and those rules are out of Taylor, which I cited earlier. But again, our position today is that some of these conflicts, particularly the conflict with Mr. Blaylock, and to a lesser extent, the other former client conflicts, including Mr. Stilwell, Mr. Kendrick, Mr. Greer, and Mr. Arnold, are not waivable conflicts. And I also do want to point the court's attention to our concern with Mr. Stilwell is that we believe his counsel is also facing a conflict, and his counsel is who got the waiver on this case. So there's sort of a double conflict here. But again, Your Honor, basically because we truly think that there is a serious potential for conflict, because basically should we wish to convey those plea offers, the attorney would not be able to negotiate that in return for becoming a prosecution witness against someone else, against, for instance, Mr. Williams, who we've of course alleged is in a leadership position in this gang, which is why these are particularly concerning allegations. And one moment, Your Honor. That's all I have for the court at this time on why we believe that this court should, first of all, request any waivers be on the record, and additionally, we would ask that this court grant our motion to disqualify Mr. Steele on the grounds of the 1.7 and 1.9 conflicts. Thank you, Your Honor.
Okay, all right. Mr. Steele, I'll let you respond, and then Ms. Rosenwasser, I'll let you, if you have any other argument as it pertains to.
Okay, that is Lisa R. So when Dawn Geary ends up leaving, like at the end of the year, she ends up leaving shortly after too. So Lisa Roseniter or something like that. Lisa R.
Mr. Schardt, and then I'll let him respond, okay? All right. All right, Mr. Bullard, good morning, sir, or good afternoon at this point in time.
Oh, yeah, we have been here a while, Your Honor.
Yes.
So first, Your Honor, I'd like to thank Mr. Geary and Ms. Rosenwasser for their professionalism and candor in foregoing the Rule 3.7 issue. We always felt that that wasn't going to bear out, that there was no way Mr. Steele could be a necessary witness in this case. I'm glad on investigation, they see things our way. As for the Rules 1.7 and 1.9 issues, however, I know that Ms. Rosenwasser didn't quite give the court the full picture of the case, or the full picture of the law. As Your Honor noted, to require disqualification, the state has to allege and substantiate a claim of an actual conflict of interest. Now, we're in a criminal case, and we're talking about the Sixth Amendment context, where one's right to chosen counsel, Mr. Williams' rights to chosen counsel.
It's not absolute.
It is not absolute, Your Honor.
So I think that the case law kind of walks us through that. So let's just kind of go through that.
Sure.
I understand he has a Sixth Amendment right to choice of counsel, but in this particular circumstance, the court has to be, you all have sought waivers, it's got waivers, that's step one. And then there are issues of whether or not there's been an ethical violation, and then the issues of whether or not there is some type of substantiation. So let's address that.
All right. So first, I'll turn this around then. As for the waivers, Your Honor.
Do you believe that I should go ahead and have those in, given what Ms. Rosenwasser has cited, I believe it's Taylor, that would probably be the better practice for me to go ahead and have a actual on the record hearing, or actually waiver. Are you in disagreement with that?
In general, no, Your Honor. There is no harm in bringing the individual defendants in, having the court inquire whether they fully understood the rights they were advised of, and whether they have actually waived the issues. There's no real problem there. I would note, however, that the rules of professional conduct describe written waivers as appropriate on consultation with independent counsel. And that's what we have here, Your Honor. We have several lawyers, each of whom have independently consulted with Mr. Steele's current and former clients, who have represented to those clients in the court and who are presumptively ethical.
I'm not in any way saying that Mr. Steele is unethical or in any way he has the highest of ethical conduct and the highest of advocacy, having watched him for the better part of 25 years. So that's not the issue. The issue is the system and its ability to be fair and transparent. So part of the challenge is unlike the civil cases that a lot of these have been quoted in a lot of your briefings, criminal cases are unique in the sense that when you have multiple accused, you have divergent interests. And as the longer the case goes, or at any point in time in the proceeding, you can get, opportunity, meaning that, and I mean opportunity in this case, because I'm not on either side, but where a deal can be struck or conversations can be had. And the court wants to ensure that all the parties are in the best position, should they choose to do so, to participate in that. And I think that, in fact, in Haidt, one of the things that the Supreme Court was most troubled by is that divergent interest and likelihood. And in criminal cases, especially where you got 28 folks, you're going to have that particular issue. And you've got 3 of these particular people, Arnold, Greer, and Blaylock, who are specifically referenced in predicate offenses, as part of the RICO count. So, I mean, in terms of substantiation, I mean, I'm not kind of commenting on whether or not the state's going to be fruitful in this, but that would be part of the reason or what they proffered. So I'm going to take judicial notice of the indictment. I'm going to have it admitted as Court 1 because it does go ahead and, Mr. Weaver, it does go ahead and give the predicate offenses that we're talking about that form some of the concern under 1.7. But I hijacked you, so I apologize. Go right ahead.
It's your courtroom, Your Honor. If I could address that.
Yeah.
Sure. In a multi-co-defendant case, there is always the possibility that there may be interest, because we don't know that at some point one defendant may want to turn on another, that one defendant may want to turn state's evidence, that someone might be able to negotiate their way out for one reason or another. The point at this point, Your Honor, that is speculative because we don't know that's going to happen.
Ms. Rosenwasser indicated on the state and as an officer of the court that is a likely that's more than a likely probability that once the representation issue is resolved, that they're going to go ahead and, as part of their prosecutor's tools, do that.
Sure. But, Your Honor, it is nonetheless still speculative. Ms. Rosenwasser speaking in the subjunctive, in the conditional. We don't know whether those defendants would be interested. We don't know what the offers would be, and we don't know whom the offers are coming to.
But doesn't that potentially pose a significant issue to Mr. Blaylock, in particular, who is still in...
His motion for new trial is still pending, Your Honor.
I know, but that's part of the conflict is, can he be offered some type of... Can they have two conversations? Can he have two conversations with client Williams and then client Blaylock on their relative equities and what they should do if given the opportunity? I don't think he can.
If that were to come up, Your Honor, if the state were to make an offer to resolve the matter that Mr. Blaylock is on, or that he has Mr. Blaylock on, in that matter with respect to this one, it might well be a problem. And again, we don't know that that's going to happen and whether that is even an issue. Or even will be an issue in this case, because the state already has a judgment for murder against Mr. Blaylock, and so I'm not sure how much more of his life it intends to take. Nevertheless, Your Honor, but when Ms. Rosenwasser also brought up the concern about the state's concern about ensuring that there's a perfect record and that that any judgment against Mr. Williams in this case would be insulated against reversal on these grounds. Well, let's talk for a second about what would actually have to be shown where that happened. Assume, for sake of argument, that Mr. Williams were convicted. The law from the Supreme Court of the United States is that he would have to show an actual conflict, which is not just a violation of ethical rules. It is not a theoretical division of loyalties, the Supreme Court says in Mickens versus Taylor. It is that Mr. Steele's representation would actually have been affected. And if Mr. Williams is going to raise that claim, he would have to show that, and and all indications are that Mr. Williams is going to trial, he would have to show that Mr. Steele's representation was compromised. And Your Honor noted that there is no question about the quality of Mr. Steele's advocacy and whether it would be compromised, and what kind of advocate he is. So it's hard to imagine that it would be compromised here. Now, if the state were to make an offer against Mr. Blaylock, one, there's a waiver already, and two, that could well be resolved by Mr. Steele getting out of that case and Mr. Blaylock having other counsel. Then that counsel could consult with Mr. Blaylock, and then Mr. Steele could consult with Mr. Williams.
How do you address the issues of the 11th Circuit and serious potential for conflict or irrebuttable presumption of disclosure of confidential information?
Your Honor, I know that presumption has never been adopted by a Georgia court. That is a presumption that's been adopted by the 11th Circuit, but Georgia courts haven't adopted it. And two, even if we were to presume the transmission of confidential information, that alone does not create the actual conflict of interest or the serious possibility of one. I turn the court to, let's say, Lewis versus the state. Actually, no, I take that back. Williams versus the state, which is cited in our motions, a case that arose out of Savannah. There, the public defender's office represented two co-defendants who were charged in a single indictment, pleaded one out, and then the public defender himself represented the court that he did not think that he could continue to represent the defendant at trial because of the then pending formal advisory opinion of the bar 10-1, which talked about the imputation of conflicts among public defenders' offices. The court inquired there, determined that he didn't know enough about the other case, that his representation in this case wouldn't be compromised, and allowed him to go forward. Mr. Williams raised that issue on appeal, and the Supreme Court affirmed because he did not show an actual conflict of interest. There was no evidence that the representation was impacted. Similarly, in Lewis versus the state, which was Rosenwasser referenced, she says it's not quite like this, but I think a little deeper dive into that case might help, because what you have there was the former superintendent of the DeKalb County Schools, Mr. Lewis, who retained a lawyer, Mr. Brown, who was a member of the firm Alston and Bird. Alston and Bird also represented a witness a witness's employer in a number of matters, and so the court inquired. There were representations made on the record that there was a discussion about whether the witness and the employer were the same, and whether there might be some conflict of interest that would cause Mr. Brown to pull his punches. And there was speculation.
It talks about the rigor of cross-examination.
Yeah, the rigor of cross-examination, which is also something the 11th Circuit talks about repeatedly, whether there is going to be, there might be a risk of disclosure of confidential information on cross-examination, or whether there might be an interest in not cross-examining as vigorously as possible. And in that case, the Superior Court of DeKalb County disqualified Mr. Brown defense counsel, and the Court of Appeals reversed.
But isn't that different than what we have here? I mean, that seems to be kind of not what's going on here in the sense of this is a little bit more involved.
Sure, it's a little bit more involved, Your Honor, but at this point, what then Judge Blackwell said in the opinion was that, one, there's no evidence in the record that any of these things would be true. And it's noted that even if counsel stated that in their place, these general assertions were not enough to base disqualification on. The rare and extraordinary remedy of disqualification of counsel of choice. And all that the court was basing it on was conjecture upon conjecture, because we're speculating out there. So the claim there wasn't substantiated, just as the claim here hasn't been substantiated. We're speculating. I would also, since we're talking about federal cases, I might also point the court to United States versus Harrison, which is cited, and I have copies of most of these cases if it would be helpful to the court. So in United States versus Harrison,
You give one to Mr. Kern.
Wait, did Elisa R. say she already had one or didn't want one? Because, look, we should want this. I don't know exactly what she said. I'm not going to rewind it, but I'd want the copy in a heartbeat to read along.
Two, please, if you have extras.
The facts are somewhat complicated, but I'm going to try to distill it down. It involves a father and son who were law partners and multiple co-defendants in an indictment. Now, the son had previously represented one of the co-defendants in a civil matter, and the co-defendant had, and then the father took on the representation of another co-defendant in the criminal matter. The co-defendant, the information from the civil matter was germane to the criminal matter, and the representations made by the by the co-defendant would have turned the son into a witness. Now, the Middle District of Georgia, applying Georgia rules of professional conduct and inquiring into the case, did not find that there was a risk that the father, who was representing the co-defendant in the criminal case, would not be able to effectively cross-examine his son and law partner. Similarly, we have, or relatedly, there was also not an issue with, there was not a showing that the confidential information might have been material to the case. So even if there's a presumption of confidential information, it does not mean that the representation will be materially affected. So the point here is, and in that case, what the court did was say, look, the lawyers are presumably responsible for figuring out whether they have a conflict or not. The government has not substantiated that there is a serious potential for an actual conflict, something that affects the representation. And if something comes up...
You don't think the predicate offenses that are listed in count 1 to Arnold, Greer, and Blaylock are serious potential conflicts?
I don't, Your Honor, because we just don't know enough. It is far too early in this process to be guessing about what's going to happen. The state may be making representations, but they may all say, we don't want anything. And they may say it to counsel other than Mr. Steele.
That would be, I mean, of course, they're truthful advocates. I mean, I'm not saying that what's in the indictment, they have to prove all the material allegations in the indictment as part of their case in chief. But certainly, if these were not in there, I would tend to believe that it's more than just mere speculation. They can prove it. So why would it be not? Why would it be speculative?
Because, Your Honor, just because those charges are there does not mean that it would be speculative that the several defendants would be interested in pleading. It would be speculative that the several defendants, that even if they pleaded that their interest might or might not, their potential testimony might or might not be potentially adverse to Mr. Williams. It is speculative what the offer would even be at this point. We just simply don't know, and there's not enough evidence to substantiate that claim. Because, well, and if I can respond to that with Berger versus Kemp, which is a case from the Supreme Court of the United States that actually grew out of Georgia, I think down in Ware County. There we have law partners concurrently representing co-defendants in a criminal matter. So each one might well have the interest in turning on the other. And they challenged their conviction all the way up to the Supreme Court of the United States, and the Supreme Court said that that was not enough to show an actual conflict of interest in that case. So it just simply does not, it simply takes more to demonstrate an actual conflict than, well, this might happen. The joint representation, the simultaneous representation is enough, because in Berger versus Kemp, the Supreme Court assumed what we would call Rule 1.10 imputation, that law partners, that it's the same as one lawyer representing, but simultaneous representation by a single lawyer in a case where they might have adverse interests wasn't enough. The multiple representation is not by itself a basis for disqualification. In fact, I think in Wheat versus, both in Mickens versus, in actually all three of those cases, cite back to an opinion by Justice Frankfurter in Glasser. It was an opinion in dissent, but the majority adopted that point that that a common defense might often be better strategy. And so the Constitution and the existence of an actual conflict does not turn on even just those opportunities. It takes more, and we are speculating. The other thing to remember here, Your Honor, is that an erroneous deprivation of counsel at this point. I mean, the state is concerned about ensuring that any judgment in its favor is stable, but an erroneous deprivation of counsel at this point, no matter what quality of counsel Mr. Williams received at trial, if he's convicted, there's no showing of prejudice or reversal. He was denied his chosen counsel. His chosen counsel, with whom he has a long-standing relationship of almost a decade, his chosen counsel who's intimately familiar with his business and affairs, whom he trusts, who has advised him in a number of matters, and who is simply not replaceable, even by other competent defense counsel, because he has been chosen. And even if the court were to find a conflict, it still has to balance the risk of the need for ethical conduct and the need to ensure the fair administration of justice against those concerns for the defendant. Even if we got there, even if the court were to find that the state had substantiated its claim, which we still say it doesn't. I'd like to sort of loop back to two other points. As far as substantiation goes, Ms. Rosenwasser mentioned Edwards versus the state, a case out of the Court of Appeals, and it grew out of the Tallapoosa Circuit. And there, the public defender, the appointed public defender, had previously represented a defendant in represented then a defendant in a child molestation matter, and the state's principal witness was the mother of the child, whom the public defender under previous practice represented, I believe, in a divorce matter. Not a divorce from this defendant, but a divorce matter. And there, the public defender himself put on the record that he was aware of confidential information that would affect his cross-examination. And that affirmative representation was enough to justify the Superior Court's disqualification of counsel, even though the defendant wanted to go on with his chosen counsel. The other thing, though, is completely different from what we have here. In Edwards, the witness, the former client, had offered no waiver, so there was no waiver of confidentiality, and the court did not accept upon investigation the public defender's representation that he could navigate around the confidential information. So he was trying to be ethical, but he conceded on the record that his representation would be affected. So there is a basis to infer that.
That's a little different because, still under rules, all of us have an affirmative duty to, if a conflict develops and the potential that at the time the conflict is present to raise that to the trier of fact. So he was doing what he was supposed to do.
Oh, absolutely, Your Honor. But the point is, when the issue went up on appeal, the court was not wrong in granting the mistrial because it concluded that he could not be effective, but there was substantiation. There was evidence in the record that would justify that conclusion, as opposed to, say, Lewis, where we were speculating, or even in.
But doesn't that scenario demonstrate anybody who's been practicing criminal law for a while will tell you that conflicts often develop kind of at an instant, meaning that when these equities change or evidence is made available.
And what happens if and when that conflict arises? That sounds like something you address when it arises.
That's when we're people that think there's not a conflict then develops, and then the court has to take other actions to either salvage or even to sometimes to re-engage the proceedings because somebody is pulled out because a conflict has developed through representation. So isn't that something that may potentially happen in this particular case, given the fact that you've got 28 folks, different equities? And I know you said this is speculation, state hasn't offered anything as of yet, but isn't that part of the issue that the court as the arbiter and keeper of the process should be worried about?
I'm not saying the court should not be concerned, Your Honor. It is potential. Potential, however, does not mean serious potential, which is what wheat requires. And
you don't think it's serious potential that we got 3 people that have predicates that are in the indictment?
No, Your Honor, I don't. Not at this point. Not without more. And
what would you consider to be more than?
An actual attempt to make an offer. If there were an actual attempt to make an offer, if the state said, all right, we're making an offer, and the court were to determine it wasn't simply to manufacture the conflict, which is another point it has to consider here under wheat. If the court were to actually make the offer, maybe we'd be in a different posture. We need to do something to address the conflict and perhaps change the posture of one of the defendants from present to former, and that's something that Mr. Steele would have to deal with. But that, or especially with Mr. Blaylock. But
doesn't that pose a problem for the people that Mr. Steele has represented in the past, in particular Mr. Blaylock, from even evaluating an offer or even being available to discuss that without the worry that the current client is going to potentially roll on them, or got the role being given adverse testimony to against their interest?
Well, let's take that for a second, Your Honor. So let's say an offer is made to Mr. Greer or Mr. Arnold or Mr. Stillwell Jackson. I know his name is Stillwell in the indictment. I think the waiver indicates that the name is properly Jackson. But let's say that offers are made to them. They're going to be made through other counsel, and other counsel are going to consult with him or with them. And other counsel are going to advise them of the risks and benefits, and they aren't going to be able to get and they aren't going to have a claim because they have other independent counsel advising them that the representation they got in this case was adverse. The only person who even might, and we're not there yet, the only person who even might is Mr. Blaylock, whom Mr. Steele represents in a different, though factually connected matter. We don't know if there's going to be an offer there. We don't know if the state's going to be willing to give up some or all portion of its of the motion of the judgment it has and it is now trying to defend against an appeal. But it just simply hasn't. Let's assume that assume for the sake of argument that Mr. Steele withdrew from that representation. Mr. Blaylock had other counsel The counsel he had then could advise
He
him.
hasn't done that yet.
He hasn't done that yet.
Right.
But again, if the state is speculating, well, this might happen, we might make this offer, Mr. Steele might withdraw. He might have other counsel. He might be properly advised. If we're talking about protecting the
How
right and
can-
the interests,
How can you represent the interests of Mr. Blaylock, who's charged in Acts 76 and 74, 76 and count 1, and the interests of Mr. Williams at the same time?
the state has conceded they're not presently adverse. So concedes that in the motion, Ms. Rosenwasser indicated today. It only indicates that they might become adverse. If they become adverse, then Mr. Steele would be the first person to come to the court and say, oh, now we have a problem. I need to either withdraw from one representation. I need to do something. I point the court back to the United States versus Harrison. At the end of the district court's order, the court recognized that there was a potential for conflicts to arise, and it reminded counsel of their obligation to inform the court should the equities change, should the conflict or the serious potential for one manifest. And in that instance, Your Honor, steps would have to be taken, but that one does not mean steps could not be taken to make sure that everyone had the rights to effective assistance of conflict-free counsel. And in addition, that any judgment obtained against them would be sound, because when they received the advice and made the decision to plead or not, they would have had the benefit of independent counsel who didn't have these problems. It simply doesn't mean that. But all of these things could happen, and it would still protect the judgment and wouldn't undermine the fair administration of justice. We just don't know yet.
Okay. Anything else?
I would come back to, Your Honor, that even if the court were to find the state has substantiated a conflict, there is a serious potential for an actual impairment of Mr. Steele's representation that could not be cured through withdrawal or something else. When it comes down to balancing the equities, we have to talk about what Mr. Williams loses in this case. He loses an excellent lawyer, one whom he believes to be the best of the best, and rightly so, and by Your Honor's own acknowledgement. And one who knows him for 10 years, who has an expertise about his life and affairs that is simply irreplaceable, and who is already, and there's also going to be a significant financial cost and loss of effort that's already been put in. And all of that counts, Your Honor. So even if the court gets there, then it still has to balance the equities before making a decision. And the burden is still on the state to show that the extraordinary remedy of disqualification is appropriate. And lastly, Your Honor, looping back to the beginning, I have no problem with the court making the inquiry that's described in Taylor, because more than anything else, that would insulate a potential judgment against reversal on these grounds, because once the waiver has been placed on the record, none of these defendants could claim they received the ineffective assistance of counsel, because they would have induced the error. And induced error is an absolute bar to reversal.
I will tell you that from what you both have stated, I will pursue it to Taylor, go ahead and probably do an in-person waiver. I think that would be prudent under the circumstances, and I'll set that up as soon as possible. So, but I definitely, as part and parcel of this particular analysis, would want that on the record, regardless of what I ruled. Okay. All right.
Okay, and this is for context here. Sheila Green had said, didn't Blaylock, Greer, and Arnold take plea deals? So Blaylock rejected a plea deal for this YSL indictment. However, he's already been convicted for the murder of Jamari Holmes. That's the case that Brian Steele represented him. And the state's argument is, well, because that is a predicate act in this indictment here, there's going to be a conflict of interest. And with that murder, I believe it might be a November date, but I think it's actually October. I think Brian Steele is going in front of the Georgia Supreme Court for the appeal on that life conviction that Blaylock is facing. So that's the overlap that they're discussing here. And, we have Brandon Bullard here arguing that, there isn't actually a conflict of interest at this point in time. Additionally, and this is going to go back to Dublin Mug, so thank you, Dublin Mug, for sending this over. I think it'd be kind of cool. You guys can see Young Thug's handwriting, Jeffrey Williams' handwriting. So he wrote this letter saying that if there is a conflict of interest, I waive it. I've discussed everything I need to know. I know about the state's motion to disqualify, and I want Mr. Steele as my counsel, so I waive any potential conflict and wish for Mr. Steele to remain as my chosen counsel. Signed on this I think that's 18th day of May, 2022. So thank you again to Dublin Mug. You guys say thanks in the chat. Drop a link here to that. The Steele, I'm going to call it Steele Response. It's also in the description of this video. But just for some context there, why we keep hearing Blaylock. Go back here. Oh, and let me make sure this isn't going to be the part where they okay, it's coming up soon. It comes up in the middle of Steele. What do we have? 3:52. We have about 4 minutes. I'm going to try to stop it before the alert noise hits our ears.
So I guess that brings us to the question, if the court's not ruling today, Mr. Steele had planned to argue the bond motion. I know there's no present adversity.
Well, here's the thing. I have to resolve the issue of the counsel first, as I mentioned to Mr. Steele, before I do the issue of bond. Because he has chosen counsel for Mr. Williams.
Yeah.
So I believe I have to resolve that issue to begin with. But let me kind of ponder on that to begin with, okay? Yes, Mr. Steele.
May I speak, Your Honor?
I thought you were represented by counsel now. You can't have a twofer, sir. It's one or the other, all right?
I'd like to answer some of your questions if it's okay with the court, factually.
All right.
Thank you, sir. And good afternoon, Your Honor.
Good afternoon.
Your Honor, I heard you ask multiple times the predicate acts in the indictment, how do the court deal with that? I need you to understand the following, please. Mr. Arnold, I never represented Mr. Arnold. You will find nothing that I have ever defended that man. I have never spoken with him about his case that there are predicate acts in this indictment.
I want to ask something. Does the state want Mr. Steele to testify about this? Because one of the things about these types of motions is there has to be some evidence. So if you're gonna, I mean, I know you're an officer of the court, you would not tell me anything inconsistent with that, but that is something that I would have to, part of my determination has to be based on evidence that has been granted, that's been given in this case.
Your Honor, the state's position is so I had planned when I went back up to ask to just have the court take judicial notice of the exhibits I had already admitted. However, if Mr. Steele would like to testify, I would just simply like the opportunity to ask him any questions I might have, but I don't have an objection to him testifying on his own behalf right now, and I can ask him some questions afterwards.
Mr. Steele, I've had one of these go up before, and that's part of what was the other lawyer that raised the issue did ask those particular inquiry under oath. Do you have an issue with that, sir?
No, sir.
Okay, all right. Let me go ahead and swear him in. Raise your right hand, sir. Do you solemnly swear affirm the evidence you'll give me in the case down here shall be the truth, the whole truth, nothing but the truth, so help you God, so affirm?
Yes, sir.
Okay, all right, go right ahead.
With regards to Mr. Arnold, there was a shooting at Lenox Square Mall. I was at my office. I received a phone call, not from Mr. Arnold, and I don't know who it's from, but it's one of his supporters. It was either a manager or a female friend, is my memory, and said, the police are all over the mall. We're afraid that they're looking for Mr. Arnold. Would you please find out if there's a warrant for him so he can turn himself in? I was busy I was either on trial or doing an appeal. It's a long time ago. There's no file in my office. I asked another lawyer in my office, not affiliated with me, named Travis Galan, G-L-A-N, to go to Lenox Square Mall and find out if you could find out who is the police officer involved. Is there anything for Mr. Arnold? Travis Galan went to Lenox Square Mall. He got the name of an officer. I contacted the officer. I told the officer that I was contacted. If Mr. Arnold needs to turn himself in, if there's a warrant, then he would do so rather than the police have to potentially, I'm not saying anything this would happen, but go and waste resources finding the man. The officer told me, meet me at the police precinct. It's not far from the Honorable Don Samuel's office. I was there, I remember, very late, 10 o'clock, 11 o'clock at night. The officer finally either showed me a warrant or gave me his word there's a warrant. I called a supporter. I said, there's a warrant. That's it. In the records, when the state raised this, they attached one page of an unsworn statement of a witness that says that I supposedly, and
Okay, it's going to do the beep.
where you don't really understand it, but I supposedly made a statement, a confession on behalf of my client. I never spoke with Mr. Arnold in my life about that case.
Okay, so I muted it there. Sorry if it was quiet on the last part. It cuts out in the middle of that, and I couldn't find an alternative stream that recorded this. So yeah, we miss a chunk there, and then feed comes back in randomly, which kind of sucks. And the Blaylock appeal is November 5th, so that's coming up. It's a month away. And I think we've heard Steele notify the court already that he won't be able to be present that day.
Is where you know what's happening now.
11 Alive is live on the scene.
Where you can
The clear distinction between my representation, these people, in the case of the state side.
Let Mr. You hired Mr. Buller. He's doing that for you. So, do you have anything else you want to add in terms of some factual predicate or anything?
Those are my, well, except for Mr. Williams. If you choose to remove me from the representation of Jeffery Williams, and I know he's represented on this motion by the Honorable Keith Adams, and I know he's on the screen. I have been with Mr. Williams countless days, weeks, months, and hours. I know his entire life. You want to talk about a representation of a client? That is the bond of an attorney-client relationship. Not like anything these other people.
Okay. All right. Anything else, sir? Okay. Why don't you have a seat up here, Mr. Steele? And
It's fine, Your Honor.
Do you have any questions you want to ask him?
We don't have any questions.
Okay. All right. Then, sir.
I'd like to respond to the argument, but we don't have any more questions for him.
Okay. All right. You can have a seat, Mr. Steele. Thank you. All right.
Thank you, Your Honor. So briefly, in conclusion, I would like to ask the court to take judicial notice of all the exhibits that I put in with my motion. Those are all court documents, specifically just showing Mr. Steele's entry of appearance on Blaylock's case, as well as his entry of appearance on Mr. Greer's case. And I do just want to clarify for the court, although Mr. Steele represented Mr. Greer on that incident, as Mr. Steele testified to, he represented Mr. Greer on the September 2020 arrest. And of course, he was successful in getting that one charge dismissed. And that, he clearly represented him on that. That's now a predicate act. The fact that the firearm that he had was stolen, that's become a predicate act. So that's the same incident. It's just a different crime charged. Obviously, Mr. Steele does still represent Mr. Blaylock. And our real concern here is we haven't made an offer to Mr. Blaylock because we really can't make an offer to Mr. Blaylock right now. And I will say, as officer of the court, we have discussed with at least one attorney the possibility of if a person or a person's wish to cooperate with the state. We have raised that to at least one attorney so far. We of course plan to raise that issue in the future. And so basically our point here is that because of the position that we are in right now, Mr. Blaylock and Mr. Williams, there is a serious potential conflict there. And I want to clarify to the court, the standard pre-trial is not actual conflict. Actual conflict is the standard if someone is challenging it on appeal following trial. What it is right now is whether there's a serious potential conflict. We have shown that there's a serious potential conflict. The court documents show that on their face. And further, Mr. Steele's own testimony shows that he did represent.
Oh, sorry, I didn't know there was another one. They cut her off. Oh my goodness. Well, wouldn't be a YSL stream without court tech issues. All right, actually, let me put the volume down and we'll get back to it, and then I'll turn the volume back up. All right. We'll go like here. Sorry, guys. Sorry. Oh my God.
Verify fact versus.
That based on not only the former clients, but especially Mr. Blaylock and Mr. Steele's current representing Mr. Blaylock on charges that are literally, they are the same incident. It is the February 2019 murder. It's the same incident. Obviously here it's charged as a RICO. There it was murder. Based on that, we would ask that this court grant the state's motion to disqualify. Thank you very much, Your Honor.
All right, let's move on to Mr. Schardt. Want to go ahead and make your argument at that point in time or add to what you've already stated?
Yes, Your Honor. So, Your Honor, again, I know the court has been here a long time this morning, so I do just want to briefly state, as for Mr. Schardt, our concern here is that Mr. Schardt previously represented Mr. Eppinger. Mr. Schardt now represents Mr. Stillwell. Mr. Schardt represented Eppinger as recently as, I believe, a probation revocation hearing that occurred this March. And the probation revocation was, the charges that were discussed in that probation revocation, what caused his probation to be revoked, was the fact that was new incidents, particularly involving the shooting of a police officer in 2022. And Mr. Schardt represented Mr. Eppinger in that probation revocation. Mr. Schardt then left the public defender's office, and I believe he's either employed by him on his own or with a firm, and he's now representing Mr. Stillwell in this particular case. However, as a result, we believe that there's clearly a conflict between his prior representation of Mr. Eppinger and his current representation of Mr. Stillwell. Obviously, this is less egregious than what we just discussed, as it's a single client and it doesn't involve present representation. However, the probation revocation in which Mr. Schardt represented Mr. Eppinger, after Mr. Schardt left the office, it was taken over by his former colleagues. The court then handed down the sentence on that probation revocation, and that is currently being appealed right now. So that's actually a pending appeal that's happening currently on a case where he previously represented the defendant. So I think that creates a conflict there. And our main concern here is that there are no waivers. So unlike with Mr. Steele, there have not been any waivers put on the record here. We don't know if Mr. Eppinger would want to waive his conflict, is willing to waive his conflict. We don't know if Mr. Stillwell would waive this conflict, although he's waived his conflict with Mr. Steele in writing only, and we would ask for that to be on the record. Mr. Stillwell has not made any such waiver on this particular case. It would be the same cases that I cited to in the previous motion, so I don't want to belabor that to the court. But again, in those district courts where that prior representation was substantially related, there is a presumption that the confidential information was disclosed. And additionally, because they were substantially related, that's sort of an even bigger problem for us, because the acts in the probate that caused the probation to be revoked, those are indicted as counts and as predicate acts in the current indictment. So those are substantially related. As a result, we would at minimum ask for this, and again, I did want to be clear, we have not at this point moved for him to be disqualified. We would like to seek additional information, whether these clients are willing to waive. Should they not wish to waive, we'll absolutely be moving for disqualification. However, we would simply like the court to essentially evaluate whether or not the court believes that this is a conflict that cannot be waived under 1.7c. And we wanted to bring this to the court's attention. That's why we filed this as a notice, as opposed to Mr. Steele's, which we filed as a motion to disqualify. Again, as with Mr. Steele's, we are not trying to deprive Mr. Stillwell of his desired counsel. We are simply trying to ensure that everything is done fairly to all parties, particularly in this case, Mr. Stillwell and Mr. Eppinger. That's all I have for the court on this, Your Honor.
Okay, all right. Mr. Schardt?
Good afternoon, Your Honor. May it please the court. First of all, I would just like to start with the same place that Counsel Bullard began and point out that I am, in fact, Mr. Jackson's, named as Mr. Stillwell in the indictment, his chosen attorney. Factually, I will say as an officer of the court that I had meetings with Mr. Stillwell, as he's named in the indictment. I'll call him Mr. Jackson. I had conversations with Mr. Jackson and have met with him about the substantive charges in this indictment prior to this case being indicted. I have been meeting with Mr. Jackson prior to the state creating what they say is a conflict by indicting 28 individuals with very different substantive charges, all on the same indictment. Now, factually, what am I referring to when I say the state has charged 28 individuals with charges that have literally nothing to do with each other in creating this conflict? Well, Mr. Jackson, in this indictment, is charged essentially with various charges, but the two events that he's charged with are a 2015 alleged murder, where his co-defendants are Cormarvius Nichols, Demekion Garlington, and Miles Farley. Excuse me, a May 14th, 2022 murder, where those individuals are listed as co-defendants, and a January 10th, 2015 alleged murder, where his co-defendants are listed as Javaris Bradford, Justin Cobb, Deamonte Kendrick, and Demise McMullen. Mr. Eppinger, whom I have represented in the past, is charged on this indictment with 3 substantive acts. He is charged with an alleged armed robbery from October 12, 2021, an alleged attempted murder, which was the alleged shooting of the officer on February 7th of 2022, an alleged conspiracy to commit murder, some allegation of something being done within the jail, conspiring to kill an individual from February 22nd of 2022. I will point out that Mr. Stillwell, Mr. Jackson, is not a co-defendant on any of the substantive charges that Mr. Eppinger is charged with. Likewise, Mr. Eppinger is not a listed co-defendant on any of the charges against Mr. Jackson. There is no indication at all that Mr. Eppinger is a witness, has any information on either of the murders that Mr. Jackson is charged with, and there's no indication at all that Mr. Jackson has any information on the 3 substantive charges against Mr. Eppinger, which would make him a witness. There is no indication that these 2 individuals even know each other, other than they're reading each other's names on indictments they're named in. The point I'm making, Your Honor, is to even get to the point where we're talking about waivers, and I will say I do have a written waiver from Mr. Jackson, who's Mr. Stillwell. But before
Do you have
we
any issue with having that done on a record pursuant to Taylor?
with Mr. Stillwell, I don't have a problem with that. And he's here, and he did discuss these matters with a separate attorney previously. So, but to even get to the point of waivers, there has to be a materially adverse relationship. There's no relationship in this case. There's none whatsoever. If the state, and we talk about the substantial likelihood, Your Honor, you've been doing this for a long time. I've been doing this for a significant amount of time. We see what each individual that I've represented in the past is charged with. The state might be willing to make offers with some people. If they're waiting to make an offer to Mr. Eppinger, who's charged with what he's charged with, then certainly they need to contact GPDC, which they've apparently filed an emergency motion today to get everyone attorneys, and they can talk to whomever is appointed to represent Mr. Eppinger, and I have nothing to do with that whatsoever. If they need to talk to me about something about Mr. Jackson, they can talk to me. That has no effect on Mr. Eppinger whatsoever. The state has relied on this Height case, and it's just, there's just clear distinction between the state's cases that they're citing, which have been found to be materially adverse relationships. And in this case, there's just no indication that these individuals even know each other. Furthermore, and I'll just, because the state has brought up my recent representation of Mr. Eppinger, and obviously, the state is saying that there's a irrebuttable presumption and they're citing federal law. I would just point out to Your Honor that that was a probation revocation. The state, prior to the probation revocation, officials representing the district attorney's office were in front of cameras telling Atlanta, telling the world what Mr. Eppinger had done. Someone, certainly not me, has released video of the incident, of the alleged incident, to the media. It's a Google search away. I asked the state for discovery to prepare for any revocation hearing, and I wasn't given any. So the idea that somehow I have some secret information when the state has been trying the case in the press from day one is ironic to me. Also ironic, the idea that there's a pending appeal and somehow that has anything to do with me or Mr. Jackson. Apparently, my former colleagues have filed an appeal of the sentence that Mr. Eppinger received. He received a lengthy sentence as a result of the probation revocation. There is a dispute, to my understanding, about the amount of time that he was exposed to as part of his first offender revocation. I did not file that appeal. That appeal has nothing to do, to my understanding, after talking to the appellate attorney, has nothing to do with the facts of this alleged incident, but it's strictly a legal question. And the idea that the fact that my former colleagues happen to represent someone on appeal and somehow that's imputed upon me, I'm just wondering out loud. I see my former colleagues working in district attorney's office right now. How many hearings has the district attorneys have they demanded to sort out the potential conflicts of imputed knowledge, of imputed representation on my former colleagues who now work with them?
But there's a process that the rules.
Okay, and thank you to Dublin Mug. So we were kind of curious about Friday, because Friday next week we were supposed to have a jury day. We knew that we were going to have Wednesday and Thursday without the jury. But when they said that no jury until like maybe the 15th, 16th, who knows, I wasn't sure what was going to happen with the Friday, if they would just not have court or if they would continue with court without the jury. But it sounds like from Dublin Mug here that probably on the Justice Served YouTube channel or podcast, Doug Weinstein said that there will be court Wednesday, Thursday, and Friday next week. So thank you, Dublin Mug, and drive safely.
Lay out, so.
Well, it's just kind of ironic that it's the focus is on this one case, and there's plenty of people that leave the public defender's office that go on to work and were present when cases were pending against people.
I think the state's just asking, I mean, they're under 1.7C for you to just clear that conflict. So, so I think that if Mr. Eppinger and Mr. Stillwell, I did waivers for those, that might resolve the issue. They may not have any more issue with you about that.
And I understand.
And they're just raising the issue.
Well, and I understand that, Your Honor. And as an officer of the court, I will. My concern is skipping a step and then it being held against me later on. Because as an officer of the court, I will say that I asked independent counsel to speak to Mr. Eppinger about it. Mr. Eppinger is now located, or at least was a week and a half ago, at Jackson. Okay? That is a place that you have very limited access to people, generally speaking. It's diagnostic. My understanding is that a conversation occurred, and orally Mr. Eppinger indicated that he would be waiving. But having or getting a written waiver has been an issue. There was a refusal to sign.
Well, and that's part of why I would like to have an additional proceeding where these kind of issues I can kind of eyeball each individual, ask the appropriate waiver questions, have them affirmatively state that they understand this and are willing to waive that, and that they've also had an opportunity to seek counsel to discuss that with them. It just makes it a little bit more. It's the more preferred procedure under Taylor. And I completely understand that, Your Honor. And I'm not even though I'm a bit demonstrative, I'm not even upset with the state for seeking this. But the reason I asked to be heard today was if we're going to go down that route. I don't know what Mr. Eppinger is going to do when he's in court. But when we go down that route, I just want to be clear that regardless of what Mr. Eppinger does, we haven't, in my estimation, and I think it's pretty clear, there's no material, they're not materially adverse so as to require a waiver even to begin with. And I'm just wary, of my clients and their choice of counsel being dictated by other individuals I don't represent. So if I thought that their interests were materially adverse, I would have never got involved with this indictment. I don't see how in the world two individuals that are not charged with the same substantive acts and for all we know don't even know each other could be materially adverse. I would think that to the extent that they affect each other at all, every individual in the indictment, their case would go stronger by other individuals doing well at trial with their substantive charges. So it's not a situation where there's any threat or possibility of blaming others or shifting the blame or anything like that, because again, they're not charged with the same substantive offense. So thank you, Your Honor. All right. Thank you, Mr. Chair.
I think we recess here.
All right, council, I'm going to take just a brief recess to consider this issue, and then I'll give you some direction on where we proceed from there, okay?
Your Honor, I'm sorry if I could just briefly respond to his argument.
Okay.
Okay, just a little more, I guess.
Very briefly, Your Honor, I just wanted to let the court know, we noticed that counsel did not mention that Jackson also has another predicate act, 173, that's a murder. Additionally, I was unsure of the context, but he mentioned someone was refusing to sign, perhaps Eppinger. The reason we're trying to see if there is an in-court waiver, that's exactly why we want to get all these folks in court to figure out what's happening. And we think that this is different from Mr. Steele's conflict. We think that this is absolutely this is probably something waivable. At this point, that's our position. We would have to learn more to see if it's not. But we do think that this could be waived by in-court waivers from both parties. But if Mr. Eppinger is not willing to waive that conflict, then we think there probably is a conflict. But at this point, we are just asking the court to inquire into it and to get everybody here and to see everybody's position on it. And that's how it differs from our motion on Mr. Steele.
All right.
Thank you.
Give me a few minutes. I'll be in recess. I need to ponder a couple of things. I'm gonna try and deal with the issue of the disqualification, and we'll see where we go from here. Okay. All right. We're in recess.
I'm just saying, I don't think they come back. My timestamp says 4:50, but it looks like, and I'm hiding it because of the banner, but YouTube tells you like when people tuned in or replayed it the most. So I don't know if people just went to this part to look at Thug on the Zoom screen. I don't know if they're talking about anything important here, because this is not my timestamp to come back, but yeah, they just wanted to look at him on the Zoom screen. I love that YouTube has this feature. Okay, so he gets back around 4 hours and 50 minutes. And he doesn't talk right away, so we'll start here. And why did the CC, the closed caption, say applause? Who clapped?
Okay, the court's had an opportunity to reflect and consider upon the state's motion to disqualify Mr. Steele, and then the state's motion for the court to inquire about conflict as it pertains to Mr. Schardt. At this point, while I do have, the court has some concerns about the potential conflict and believes that they're great. Unfortunately, Ms. Rosenwasser, I don't think that our appellate court has adopted the federal standard of irrebuttable presumption of disclosure of confidential information. And I understand about the serious potential for conflict. I don't think that we have that yet as to Mr. Steele as well as Mr. Schardt. What I'm going to do is I'm going to deny the motions at this point. However, I'm putting all counsel on notice that there is a strong possibility that given discussions that may be had in the near future or that are beginning to be had at some point in time may require reevaluation. And I know that all of you are ethical counsel. I've had many of you here before me for over the period of my judicial career, and know that you will honor that responsibility, that the rules of professional responsibility placed upon you as advocates. But what I would like to do in the interim, that I think that the state has raised under Taylor, and that is to actually do have a waiver proceeding where the court can inquire as to each particular individual and make sure that there are no potential, that they understand the waiver proceeding and just further satisfy all of us that there's no conflict, and give all of them an opportunity to seek independent counsel to advise them on the waiver. So what I would like to do from all of you at this point in time is to just get, because I am going to have to figure, your schedules in terms of booking this, because I am going to have to find some of these folks in the Department of Corrections, which I will ask the state for your assistance with. Mr. Chamberlain needs their DOC booking number and their location. So, so that I would like to do that. But circling back to my original decision, if I need to revisit that at any point in time, state. I'm sure you'll let me know that. And then also, like I said, I'll remind all councils, if there's a issue of a conflict that arises given conversations or other preliminary proceedings, then please notify the court immediately so we can go ahead and I can reevaluate that particular issue. But at this point in time, the court's concern is under Lewis that it's speculative, but I do have some concerns. I have some really strong concerns given the fact that the number of people you're dealing with, 28, the equities that are involved, and even our Supreme Court indicates that the potential for divergent interest is great. And that's where I think we may have some issues in the future, but may have or potentially have is not really the standard in this particular situation. So that's why I'm going to deny the motions for the, at least as it pertains to Mr. Steele for disqualification. But I am going to, Mr. Schardt, to the extent that it is necessary, go ahead and inquire about the waiver proceeding for both for Mr. Eppinger as well as for the other folks that are involved. So with that, any questions about the court's first ruling or first?
No, sir.
I'm not going to deal with bond quite yet. I'm not getting to that quite yet. I'm going to deal with that next. Okay.
Your
All
Honor.
right. Yeah.
Our question would be, is your ruling conditioned on everyone actually waiving? Because at this point, we don't even have a waiver written or otherwise from Eppinger.
No, I'm going to require everyone to be present for or either via Zoom or that's how I'll probably handle it and make sure I get a waiver from everyone. So I'll revisit the issue of conflict after we do the waiver. Okay.
Thank
All
you,
right.
Your Honor.
Yeah. So and it will remain an issue, as I mentioned, because I do think that as we go along in representation, there may be a conflict because if you start offering or people start volunteering, that's when you're going to have some other issues that kind of come forward. But not right now. All right, so that's that. Okay, so in terms of the waiver and who will need, folks, we're going to need to locate Mr. Arnold, is that correct?
Yes, Your Honor.
Okay, Mr. Greer, Mr. Blaylock, Mr. Eppinger.
Mr. Evans is number 4, so
Okay.
they just need to provide the actual DC number. He's already seen the way he's acting.
Okay, is there anybody else that we need to inquire about a waiver?
Do you want to do everything?
That would probably make sense.
Your Honor, those are the ones that we raised as related, but we think it would make sense to do one for everybody that Mr. Steele has represented. That is in this case. So,
That he's mentioned, so Mr. Steele, I think there were a couple other folks that we...
Mr. Kendrick.
Mr. Kendrick, is Kendrick?
Yes, he was here this morning, I think.
Okay, and then who else?
Also Mr. Stillwell, who is obviously right.
Okay, Stillwell, all right, okay.
I think that is all of Mr. Steele's prior.
Mr. Steele, is anybody else I missed, sir?
No, Your Honor.
Okay, all right. So what I want to do is now that I've identified all the folks for waiver, we need to kind of talk about when I can actually hear or have that proceeding done. So I know that July, do you all have conferences for the public defender? I mean, for the public defender and for the state. And I know the court has one early August, but.
We start, I believe, on Sunday the 17th, I believe, Judge.
Oh, what month?
July, Judge.
Okay.
And we're normally out that week or most of that week, Judge. I think Mr. Smith and I have already filed a leave for that week to cover it. Okay. But other than that, I believe we're open in the future other than that week, Judge.
Other than the week of the 17th? Like,
Yes,
so that would be the 17th through the 22nd?
whatever that week of July is, yes, Judge. I believe the 15th is Friday, so the 17th will be Sunday, 18th probably Monday.
Yes,
July.
sir, that's correct.
Yes, sir. That week we filed a leave for. Other than that, I believe we are at the discretion of the court to be here when you need.
All right, Mr. Steele or Mr. Adams or Mr. Schardt, any conflicts during the month of July? I mean, I'm going to probably, more than likely, I'm looking at early August, I'm thinking.
Go ahead, Ron.
I'm fine, Your Honor.
All right, well, guess who's not? Judge, in the month of July,
I'm not talking about.
Not July at all, just August?
Yeah, because there's too many conflicts. People like, like take vacations and have kids and camp and other assorted things that they need to kind of take care of. So
Yes,
I was
sir.
trying not to compete against that issue. So
Yes,
I
sir.
was thinking probably sometime
Let's
in
two
early
times through
August.
this.
So along those lines, I've got to leave between August the 3rd and August the 10th.
Let's get through this.
Yes,
I guess we could just
I'll
go
be
to when
available.
Steele stands up.
Ms. Chamber? How's all this? Well, no, we have jail. We have people at the jail.
And in short, they're just figuring out when to like reconvene. And after we get the written waivers from people that may have a future conflict, blah, 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 blah. So they're going to wrap up this disqual. Obviously, they're not getting disqualified. And setting a date to make sure that the other instances, there's no issue with the representation. And then we're going to get into the beginning of the bond arguments for Jeffery Williams. I don't think we'll have enough time to start getting into the state's response, so we won't get into the hoverboard witness. They call him during this bond hearing. I think you guys will kind of enjoy that one a little bit. That will have to be part 3 at 6 p.m. I have to close this by 6 p.m., but coincidentally at 6 p.m., Dolly's going to be live talking about the Wade Wilson case. And what's interesting there is there's this rumor that really seems not to be true. There seems to be this misrepresentation by one of the girlies calling Wade Wilson, trying to be one of the jail boos, acting like the Innocence Project is trying to help Wade Wilson with his appeal. Which I really don't think is the case, but interesting to see someone play that, and Dolly's going to be looking into it. So when we do end this, this will redirect over there. I did also want to take a moment because it's like 3-4 hours from now. Flesh of the Gods will be doing rewinds, not pre-trial, but more rewinds from within the first 100 days of the YSL trial tonight at 9 p.m. So those are 2 things to pay attention to and tune into after this stream. So we'll see where we get. We will see where we get.
So you have somebody be looking at phone.
No.
Okay. When does Steele start arguing this bond?
You can't do
I knew as soon as I hit the keyboard to move forward, it would do this buffer thing. And yes, Casper, jail boos, but not boo like a ghost. This is why I don't skip forward like that. It just breaks the stream. And exactly, Jim R. It's just hilarious to see.
I'm going to make a call to Department of Corrections and see whether or not they will have that date. I'm looking right now, just for planning purposes, on the 18th of August. So if nobody has any conflicts for that time or for that date, I'll see if they are otherwise available, we can make these folks they're in DOC custody available. So I'll circle back to you in that second, in that regard, just a minute. Let's move on at this point in time, since I resolved the issue of representation for the time being. Mr. Steele and Mr. Adams and Mr. Schardt, I'll turn to the issue of bond. So, Mr. Steele, if you want to be heard on the issue of bond as it relates to Mr. Williams, go right ahead, sir.
Judge?
Yeah.
I'm sorry, can we arraign him first, Judge?
Oh, yeah, you know something, I didn't know whether or not Mr. Steele, have we arraigned Mr. Williams already?
No, sir.
Okay, all right, then let me go ahead and do so. Mr. Williams, raise your hand for me, please. Okay, I'm going to unmute. Violetta, can you unmute or, yeah, there we go. Wonderful, I got you. Okay, all right. Mr. Steele, would you like to enter a not guilty plea on behalf of your client, waive formal arraignment, otherwise have 10 days to file motions upon the receipt of discovery, sir?
Yes, Your Honor, except would Your Honor consider 60 days for motions like you did with one other person?
Mr. Abt, his client, I think, yes, that's fine.
Thank you, sir.
Okay. All right, that's granted, sir. So if you would turn now and talk about the issue of bond, you can go through all the factors and the factors you feel are necessary to make a bond termination. And right now, I'm going to say, just it goes without saying, 9 January of 2023 is the trial date, and I am in receipt of your demand for a speedy trial pursuant to 17-7-170. And I note in your motion that you're aware that the speedy trial
court trial
has been
date
told by Chief Judge Brasher by order until, I want to say I think it is the 3rd of January. We're going to check 2023. Oh, it ends on January 1st of 2023. So we'll keep that in mind in terms of scheduling. Okay.
Of course.
All right.
Thank you, sir.
All right. Go ahead, sir.
I may just have one moment.
And remember, jury selection ends up taking 10 months.
Your Honor, there are 2 people that will be proffered. For but they're in the waiting room, the Honorable Court's waiting room on Zoom. Is there any way the Honorable Court would allow those two people in?
Who are they?
Amina Diop and Garfield Lemon.
I do not have anybody in the waiting room right now, other than I assume that your beloved wife, Ms. Steele, is in the waiting room, and then I have a Justin French and a Kendi's iPad. So we have otherwise restricted that unless you're a witness or counsel, since we are in a public forum. So if you want to make a phone call and have them join the Zoom, but are they going to testify as a witness, and what are they going to testify as to?
Yes, I would proffer the two, but I thought you'd want to hear that.
You can proffer them. That's fine, sir. Yeah, but they're not in the waiting room at this point in time.
Your Honor, may I approach?
You may.
May it please this Honorable Court, I wish to thank you for all the time that you give to everyone, always. Your Honor, on behalf of Mr. Jeffrey Williams, Mr. Adams and I respectfully request, along with the Honorable Avis Hornsby, bond to be set today. Your Honor, I give a case law to this Honorable Court, as well as the prosecution, and Mr. Adams. Mr. Williams is aware of this case law, Your Honor. And the first case I gave this Honorable Court is Coward, C-O-W-A-R-D-S versus State. It's 266 Georgia, 191. It's a 1996 case. And on page 2 or 3 of the copy I've given this Honorable Court and the parties, the right-hand side, it's in Division 2. It's 15 lines up from the end of the paragraph, first full paragraph on the right-hand side. And it reads that the defendant's guilt or innocence of the underlying charge is not an issue at the bail hearing, especially since the defendant enters the proceedings cloaked with a presumption of innocence. And then the court explains that in the next lines, skipping 2 lines in the middle, the decision of defense counsel to bring the extraneous issue of guilt or innocence into bail proceedings did not preclude, and goes on to
I'm not going to consider anyways. That's well settled. That's a well settled premise, Mr. C. We can move on from there.
In the United States versus Solano, S-A-L-E-R-N-O, which is 481 U.S. 739. It's 1987 on page 14.
Of 20?
Correct.
Okay, all right.
And on the left-hand column, Your Honor, that last paragraph in the Division 3, the highest court wrote, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. We hold that the provisions for the pretrial detention in the Bail Reform Act of 1984 fall within that carefully limited exception. The Act authorizes detention prior to trial of arrestees charged with serious felonies who are found after an adversary hearing to pose a threat to the safety of individuals or the community, and this is what I stress, Your Honor, which no condition of release can dispel.
All right, sir.
In Jones versus Grimes, which is G-R-I-M-E-S, 219, Georgia, 585, 1964 case. It's cited often, Your Honor, on page 3 of 4. On the very top right-hand side, it's in Division 1, the High Court wrote that excessive bail is the equivalent of a refusal to grant bail. And that's what my issue was. I just want to point to court, because in the next case, which is Coleman, C-O-L-E-M-O-N versus State, 361 Georgia Appeal, 901. Your Honor, this came out recently, in November of 2021, so maybe 8 months ago. It's on page 3 of 4. It's the appellate court, or second highest court. It's talking about excessive bail, which obviously is equivalent to no bail. And then the court wrote on the left-hand side, on the in the paragraph that is indented, excessive bail is prohibited by the Georgia Constitution and the 8th Amendment to the United States Constitution. For purposes of the 8th Amendment, excessive bail is defined as bail set to an amount higher than an amount reasonably calculated, and this is what I'm stressing, Your Honor, to ensure the presence of the defendant. When fixing bail in Georgia, a trial judge's foremost consideration, and it's stressed in the text, Your Honor, is the probability that the accused, in this case Mr. Williams, if freed, will appear at trial, and to a lesser extent, which is also emphasized in the text, Your Honor, the accused's ability to pay, the seriousness of the offense, and the accused's character and reputation. A defendant who seeks release on bail has the burden of showing roots in the community that the defendant does not pose a significant risk of fleeing, threatening the community, committing another crime, or intimidating a witness. Your Honor, if you then look on the same page, on the right-hand side, the last paragraph, again, the court writes, and we're reminded, certainly we are not unmindful of the length of Coleman's pretrial detention and the presumption of his innocence. Your Honor, in Brown, which is B-R-O-W-N versus State, it's 314 Georgia Appeal 1, 2012 case on page 3 of 3. On the left-hand side, in the second full paragraph, the appellate court wrote, the General Assembly, which is our General Assembly, provided for the creation of programs of electronic pretrial release to, among other things, assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release and monitoring and home confinement. Indeed, the General Assembly found that a, quote, program of electronic pretrial release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Thus, the General Assembly explicitly recognized a defendant's home as a place where he or she could be kept within bounds and restricted in movement for purposes of electronic pretrial release program. The next case, Your Honor, because we are going to ask for home confinement as an electronic monitoring. The next case is Ayala, which the court already noted, AYALA versus State 262 Georgia 704. Your Honor, on page 2 of 3 that I've given this honorable court and the parties, the very top left-hand side, our highest court wrote, the purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of the person in court for trial. And then it goes through the four-part test, which is indented, Your Honor. On the the right-hand side, Your Honor, the first full paragraph in the middle, our highest court wrote, in this state, unlike many other states, the presumption of innocence has always remained with the person accused of a capital offense, even during trial. The most fundamental premise of our criminal justice system is that a person ought not to be punished for a criminal offense until the state demonstrates guilt beyond a reasonable doubt. Unless the right to bail before trial is preserved, the presumption of innocence, secured only after centuries of struggle, would lose its meaning. Your Honor, the last case is Dunn versus Edwards. If I gave it to you, if I didn't give it to you, I apologize.
No.
Okay. I will then hold it for a minute. And then I'll say the last case, did I give the court easy out bonding versus state? That is 224 Georgia Appeal 706, 1997 case. It's on page 3 of 3, Your Honor. The second to last paragraph on the left-hand side, and the appellate court wrote, it is further assumed that appellant who has taken a financial risk, appellant in that case with the bonding company, in ensuring the defendant's present at trial would be motivated to keep track of the defendant's case and prevent the defendant's flight or relocation until the surety is relieved of its bond obligation. Such risk of flight is inherent in the criminal justice system, without which there would be no need for bail bonds or bail sureties. We have a bail bonding company that is here today, Your Honor, that will be representing that they would be willing to go on Mr. Williams' bond. They have vetted Mr. Williams, and they will be heard. Your Honor, with that being said, that is the premise of our law, and I'd like to call as our first witness Mr. Charles Middelstadt.
What's Mr. Middelstadt going to testify to?
Hey, that's a familiar name. That is a familiar name. That is the cell records, the summary witness proposed by Stephen Sadow in the Fonnie Willis disqualification hearing. He's done a lot of work as a private investigator, including looking at things like cell phone records, but he does a lot of other stuff as well.
Your Honor, he is a private investigator. He is good standing throughout our state. I know him personally. And he is going to talk about his efforts in securing home confinement with current law enforcement officers working second jobs, detail, 24 hours a day, 7 days a week, to ensure that Mr. Williams is confined to his home, no contraband, no weapons, no flight, no visitors come to his home whatsoever, and Mr. Middelstadt has done all this work in the case.
Okay. Swear to Mr. Middelstadt, please. You need to stand up, sir. Stand up. Stand up, please. I'm sorry.
You swear to the truth, you got it. I do. That's it. Please state your name, stand in the courthouse.
My name is Charles Middelstadt, and the last name is spelled Mittelstadt. And my occupation is I'm a criminal defense investigator.
And Mr. Middelstadt, would you do me a courtesy and give this honorable court your background?
Yes. Excuse me. Your Honor, I've been involved in this profession. I started out in the security industry. My background is in corporate security and dignitary protection. And then for the last 25 years, I've been involved in criminal defense investigation. I've been both a board certified security professional and I'm a board-certified criminal defense investigator.
You can tell he
I've done
testifies
cases
a
coast
lot,
to coast
talking
now
right
for the
to the
last
judge.
25 years. I've done hundreds of cases here in Fulton County. I have worked with the DA's office in assisting them on cases. I have helped represent members of the DA's office at the highest level, and worked with former DAs in private practice post career in their after they left the DA's office. So I've had extensive experience at this, and I've had the opportunity to be a part of similar sort of efforts that have been responsive to trying to address the concerns of the court as consideration with regard to bond. And Mr. Steele contacted me for that purpose to try to craft some solutions responsive to concerns that you might have, and to do some investigation into different circumstances that might be present with regard to some of the offerings that Mr. Steele is going to make today.
Investigator Middelstadt, would you tell this honorable court, first of all, do you have any relationship with Mr. Jeffery Williams, who's on the Zoom?
I do not. I have not met him at present.
Okay. Tell this honorable court what specifically I asked you to do, and explain what you did, and take the court through every scenario of what we are proposing and through your work.
Okay. When you contacted me, you asked me to get with Mr. Williams' representatives for the purpose of having access to the various properties that are within his control. There are 4 such properties located within the metro Atlanta area. For purposes of evaluating the potential of these properties for home confinement purposes. And looking at them from the perspective of a security professional, and in terms of what the staffing requirements might be for each property, and the feasibility of creating a home confinement program, and what those staffing requirements might be for law enforcement, currently certified, post-certified, only law enforcement staffing with regard to a home confinement, essentially program that also would include ankle monitoring, 24-hour, 7-day a week, physical monitoring performed by off-duty law enforcement, and including making contact with law enforcement officers around the state that would be available to perform such a function, that would be authorized by their departments to perform such a function, that are ready to go as we speak today, that are ready to mobilize right now. And to date, I have secured 24 such officers that are authorized and ready to mobilize for this sort of assignment. The purpose of doing so and using law enforcement only is because they are active, they are sworn to uphold the laws of this state. They would be responsible for reporting any sort of violations that might be committed by Mr. Williams should he not comply with the terms of his bond. And so by utilizing active law enforcement only in lieu of utilizing private security or private investigators or anything lesser than a post-certified officer, we seek to provide comfort both to this court and to the state, responsive to the concerns that I've heard. Frankly, I sat through the first hearing a week ago, and I was relieved to hear that what we crafted is entirely responsive to the concerns that I've heard from this court, which really revolve around the issue of witness tampering and any other concerns that could arise from communications that might occur.
And Investigator Middelstadt, is it fair to say that we did all this work well prior to the Monday, May 23rd, 2022 initial hearing that you're referring to?
Yes, as a matter of fact, if you'll note, Your Honor, the letter that I addressed to you was dated May 20th, and so this was everything that's contemplated within this proposal here was crafted well before, and it contemplated these sorts of concerns, and candidly, it's the most extensive, far-reaching effort that I've ever been a part of in terms of trying to directly address the concerns that could be anticipated in such a wide-ranging indictment with 28 defendants and 56 counts, and the nature of these sorts of allegations. And so, in addition to the home confinement piece, ankle monitoring, a GPS ankle monitor for Mr. Williams, literally 24-hour, 7-day-a-week law enforcement. There are 4 different settings which have been contemplated some which, based on my estimation, would require 2 officers, some which could require 1 officer only. And very candidly, we're completely, I have the staffing and we have the ability to supplement the staffing to any force level that we need to. So if Your Honor decided that we need 3 officers per shift, that's feasible. If the state, and the way that I have contemplated this is whatever the state, whatever concerns they may express, we have the ability to respond to that. Part of that contemplation also deals with the fact, incorporates what I'm terming a hammer, which is a 60-day reserve. So the best way I can explain that is there's 60 days worth of advance funding, and this is an incredibly expensive proposal. Just doing the math based on 2 officers, Your Honor, the cost to Mr. Williams is in excess of $1 million a year just for the staffing alone, and there's additional fees on top of that. That math is based on 2 officers per shift times 3 shifts at a negotiated rate of $60 an hour. That is what law enforcement is requiring to undertake this sort of off-duty assignment. And this is money that he'll never get back. This isn't like a bond. This is money he'll never get back. It's a tremendous amount of skin in the game. But in addition to that, there is a 60-day workforce reserve incorporated. So if he were to violate, for any reason, that 60-day reserve would be dispersed amongst the officers that are working that assignment. And so it almost gives them an incentive to violate him in a sense. Beyond that, this plan also ensures that whatever restrictions the court puts in place with regard to limiting and restricting and controlling visitor access or any sorts of devices or any materials that you would not want within that environment, that law enforcement, not me, not the defense team in any way, but the law enforcement officers that are assigned to this responsibility are empowered to actually control everything that comes in and out of that environment.
So if somebody comes to my house and it has a burner phone, or are they going to be searched or whatever before they come in? Or?
Yes, sir, absolutely, Your Honor. What's contemplated is the moment that you approve this bond, that prior to Mr. Williams occupying it, is that a complete search will be conducted of that, whichever property you deem, whichever property you assign. It will undergo a complete search. That can include canine drug dogs. We'll do whatever it takes to satisfy Your Honor. And we will search that and we will bless that environment. And from that second forth, law enforcement will be put in place and nothing will come in and out of there. And I think that's very, very significant because what we've heard, and I have heard, throughout these proceedings is almost sort of an admission by the state at its, frankly, inability to do so in a detention center. I mean, we've heard the state talk about the fact that, in fact, it's even in the indictment, there are charges relating to the...
Okay, well, let me just pause it. I was trying to pull Survivor Speak's channel link so I could say, hey, if she ends up doing a rewind on the Darrell Brooks case, subscribe and you'll be able to see it. But she's also recently done recaps of other cases and is also doing YSL content. So when I pulled that link, that's what made the stream buffer. So pasting that in the chat now. And let's see if...
possession of communications devices by incarcerated persons. We've heard about drones being flown in or attempts to drop phones in. And we know, we all know that the fact of the matter is, in spite of all the best intentions of the good men and women of Fulton County Sheriff's Department or the Cobb County Sheriff's Office or frankly any detention center around this country, is that contraband gets in, whether it's in the form of phones or it's drugs or any other sort of contraband. It's just the fact of the matter is detention centers are just wholly unsuccessful in keeping that out.
This is such a good argument because they're having a huge issue with this content. I mean, they're still having issues with this today, to this day, right now. But right as the time of this hearing, this is June of 2022, when there was all of the April 2022 panic because Christian Eppinger got out on bond after almost fatally wounding a police officer. He shot at 2 police officers. Somehow he gets out on bond on day like 71. He didn't even reach like the 90-day limit where an automatic bond was supposed to kick in. And around that time, there was also big press about, there's contraband being found in all of these cells. We're hearing a bit about it in this bond hearing too, when we were talking about Deamonte Kendrick and Yak, and the state was saying, like, deny bond for Yak because he's trying to get contraband. He's trying to use phones to make jail calls using somebody else's code to disguise that it's him doing it. This is just such a timely and great argument for this guy to be making. Look, your detention centers can't stop the bad behavior that you're trying to prevent. So even if you don't want to let this person out on bond because you think you'll be keeping people safer by keeping him in custody, well, not really, because your detention centers suck. Like, people are sneaking in chicken pot pies, contraband phones, making shanks. Like, we have like 3 overt acts. Well, not even overt. We have all these different citations of, how many times is the word shank mentioned in the indictment? We're going to toggle over there and do a quick Control F and find. 7 instances of the word shank. So this is just such a great argument that Middelstadt is making here. I love it. I love it. Your detention centers suck.
It does not come through visitors. It mostly comes by the jailers themselves. And we've also heard testimony and proffers by the state about the fact that there are other ways to beat communications if we're talking about threats being called in or any sorts of orders being called in through code sharing and other means of making that happen. If the real concern is, in this case, accepting the...
One more sidebar, one more pause. Speaking of Christian Eppinger, because he was mentioned earlier in this, remember, he had like a little thing going on with, I don't remember the deputy's name, but remember Judge Shakira Ingram recused herself because she was like, look, I had an instance in my courtroom where, and the deputy's now in custody too, but like my deputy was messing around and sharing birthday cards and doing who knows what with Christian Eppinger. So, like, your courtroom has some issues, your detention centers have some issues. Call it out, Middelstadt.
The state's concerned that their face value is to basically freeze Mr. Williams out, eliminate his ability to communicate, eliminate his ability to present a threat to anybody. This is the only plan that's going to be responsive to that. The state has demonstrated, or not the state, the law enforcement, unfortunately, based on its, again, in spite of its best intentions, has demonstrated an inability to do any of that.
Wait, 1 second. Mr. Steele, do you have that letter that you included in your materials from last time?
Of course.
Can I have a copy of it, please?
Of course.
I mean, I know it's in the binder we submitted last time, but you have a copy of that.
I do. And Your Honor, I'd like to give I redacted parts because I didn't think the court would want the law enforcement officers' names, but we have that as well in additional names. So if you want that, they're unredacted. Thank you, sir.
We hadn't gotten it yet, but I just wanted to take a look at it, so, okay, all right. All right, go ahead, continue, sir.
In addition to that, we also make provisions for closed-circuit television monitoring. There are a couple of these properties that already have fairly extensive surveillance systems in place, and we'd be happy to turn over control of those systems, access to those systems to whoever the court deems fit, whether that's even the state or the Fulton County Sheriff's Office or anybody for that matter, whoever you seem fit or wherever that comfort level may arise. And we also are willing and capable of adding additional cameras to increase the monitoring.
Mr. Middelstadt, may I ask you a question?
Sure.
About the video surveillance, outside the home and inside the home?
Both inside and outside.
And if, let's say, this honorable court set bond, but with all these requirements, and wanted the opportunity to have certain designated people, whether the sheriff, prosecution, and the honorable court itself, to have access to the to see for themselves live video or the past video, would that be able to be done?
Absolutely.
Thank you. I apologize.
And And then can you imagine if they have like this security footage inside? So the whole time he's having this, they just like also stream it to YouTube as like a revenue source or something. Oh, this trial could have been so different.
Mr. Steele, through your witness, can you tell the court about the issues involving communication in terms of phones, email, internet, and other third parties that would come to the house? Because one of the things that the court was made aware of was the potential to engage in this trade or occupation while he's pending trial.
Your Honor, we will go to the extent that we will agree to a condition as far as there's no electronics in that house. There's no internet in the house, there's no cell phone, there's no burner cell phone. Anybody who comes into the house, if approved, they would be on a list. They would be patted down and wanded, by the way, and if it's a woman coming, they would have to have a designated time because there'd be a female officer to pat down that woman. As far as work for Mr. Williams, we contemplated, if the court permits, building a studio in his home, wherever of these 4 homes, if the court ratifies and approves, and those people would, of course, be searched, and then all that equipment would leave, and there would be a search of the house as well, or the apartment as well. So we thought about it, Your Honor, and Mr. Williams is aware. I've spoken with him personally about it. As opposed to the way he's living now, he would live without, he would go back to the time I was young, and there'd be no electronics whatsoever.
Will there be people present when he has other people in the house, other law enforcement present?
We had that discussion as well, and we would have video surveillance. Mr. Williams would waive any privacy rights, would be in the house, and law enforcement can be present at the same time. Or, and we're not asking for this, but Mr. Williams can have 0 visitors in the house as well, except obviously his lawyers, doctors would have to go see him, and we would hope family members and business associates. But if the court says, I'm willing to give a bond, but no one's visiting him, we would take that as well, except obviously I'd like counsel to go.
Oh, well, you were, Bill's not saying.
Okay.
You would be able to visit him as well as any medical providers or whatever. Okay, anything else, sir, you want to ask Mr. Millsap?
With regards to drugs, there's allegations of drugs in the home. I heard you mention drug dog, drug testing, if the court wanted drug testing to occur.
That's correct. Again, this plan essentially contemplates addressing any and all concerns of this court and the state, frankly. And we have the ability, and I will make it my personal undertaking and responsibility to secure any and all necessary, whether it be a canine dog or any sort of drug testing, any experts we need to pull in to satisfy the court's concerns. As Mr. Steele had touched on, you know, one of the things, Your Honor, that we wanted to ensure you of is the fact that we had in place the ability to do thorough screening. And so that's why we do have both male and female officers, so that we have gender appropriate screening and pat downs and wanding for the very purpose of keeping out anything that you deem to be restricted. And I've heard you loud and clear over the last 2 hearings about the concerns with regard to communicating and the potential of threatening witnesses. And so paramount to that is the ability to keep those devices out, to keep those to prevent that very thing from happening.
And if a visitor stated, you cannot wand me, you cannot pat me down, you have constitutional rights, what would be done with that person?
They would not be allowed access.
And there'd be reports each day by each shift, is that fair to say?
That's correct, and I'm sorry I failed to mention that. The plan would be for the officers at the end of each shift to, during their shift, they would be generating activity logs to be completed at the completion of their shift, and then on once a day, we would upload to a cloud, through cloud access, all 3 shifts, the reports for that day. And those could be, again, available to whoever the court designated needed access to have those, including the state. The state, I'm sorry.
And with regards to weapons, there'll be no weapons in that home. By weapons, I mean hand grenades, handguns, whatever it is. Same thing?
I think it goes without saying, there would be
Okay.
no weapons in that home. We would seek to keep all of that out.
Now, when Mr. Williams does have to come to court, would there also be provisions that he'd be transported to and from court by the sworn law enforcement officers while on bond?
Absolutely.
So he will never leave that home except in the custody control of lawful officers who are off duty but sworn. But if he refuses that, they report it to the court as a violation of bond.
That's correct.
Okay. Did you leave anything out, Mr. Middelstadt?
I don't believe so.
If the court wants to hear about the different locations, Your Honor, we can do that. Otherwise, there are 4 different locations, Your Honor. Mr. Middelstadt did write about them. We did redact. Obviously, we can give the state the exact addresses in this honorable court, but for privacy purposes, we did not file that with the record. And, Your Honor, each one of those, or I'm asking you, Mr. Middelstadt, each one of those locations, 4 locations, have they been vetted and approved for this type of detail?
Yes, I personally visited each one of those and vetted those and assessed the various features associated with those, which I have enumerated in this letter to Your Honor. And I stand ready, and I'm certainly willing to provide any more details or answer any additional questions with regard to any one of those locations.
And then finally, if this honorable court grants bond, conditionally that the house which is chosen for Mr. Williams to reside is then properly swept, approved, sealed, all that goes to the court and the prosecution. The prosecution can bring in people if they want as well. You would have a sworn law enforcement officer meet Mr. Williams outside of the release area of the jail at the Sally Port. Is that your understanding?
That is my understanding.
So it's not like Mr. Williams gets in a car with one of his family members. He would be right from the sheriff of Fulton County into the hands.
That's correct. He's essentially remaining in custody, but remanded to the confinement of his home.
Okay. Now, with an ankle monitor, since I gave this honorable court the option, or suggest, I don't give the honorable court ankle, but suggested that if the honorable court was troubled, electronics would be removed. It's not my first choice, but if that happened, the ankle monitor, to your knowledge, can an ankle monitor work without there being electronics in the home? And if you don't have that information, there's another person here to talk about.
I'll defer to that other person.
That's fine. I want to thank you. Is there anything else that I've neglected to ask you that's important to this honorable court?
I don't believe so.
Okay, and the off-duty police officers, right now, they have been given approval for this type of detail?
They have, and I have been reassured of that. And as late as this morning, once again, I have reconfirmed that all 24 officers are still good to go.
And if there is a visitation list that has been approved by this honorable court, those visitors lists would obviously go to each detail. Is that fair to say?
Correct.
Okay. I don't have any other questions for Mr. Millsap. Thank you so much.
Cross. Mr. Geary. Okay. All right. So you can stand out.
Thank you.
Thank you.
Your Honor, we would call Mr. Jamil Mitchell, which is Jamil. Mitchell's Mitchell.
So we're going to hit the brakes here because I got to stop at 6 and we're going to be redirecting over to Dolly Talks Wade Wilson / potential innocence project scam stream. So that will be a good time. I'm going to grab that link again just in case the redirect is funky because sometimes it does that. And we'll pick up with the remainder of this in a part 3. I know they call a few different witnesses. And I really can't wait to get to the story of the hoverboards, the mall cop guy. And what I think is a really crazy argument, and not crazy because it's not, I think it's a great argument, is everything would be safer if you let us run this ourselves. It's not just like, here's a defendant that's willing to pay for the security, the lockdown, to make sure they're in custody, following all the procedures, no communications, there's no risk of witness intimidation if we follow these procedures. But the argument that it would be safer to not have them in the jail. They'd be less likely to be able to sneakily find a way to communicate. And just in case you guys don't remember, this is Christian Eppinger and the deputy. I forget her name. But that was the deputy that was like helping bring contraband, the Fulton County deputy that was helping bring contraband and had some relationship going on with Christian Eppinger. And I think that was uncovered a year from what we're watching here with the bond hearing. June 2023 is when Christian Eppinger, that was all found out. And this bond hearing is again back in June of 2022. So, you know. So good times, good times. Oh, man. And not for nothing, but you'd also wonder, like, all these shankings and whatever in jail, if it's so scary, if Jeffery Williams really commissioned the unaliving of someone that was a top-ranking blood member in Georgia, in the state of Georgia. Seems like you need super high security because you'd be preventing against supposed retaliation for something he supposedly did if the streets thought that that's what he did. So a lot of this just I know it's not an easy ask to ask for a bond for someone that's charged with being the leader of some type of gang that's alleged to be responsible for multiple murders. But still, watching this with what's offered, kind of incredible. Kind of incredible. And remember, this was renewed. This bond motion, still renewed this back in June. Or maybe it was July of this year, after there was all those delays. So we're going to close this up here. I'm going to go back. I have timestamps added into the video if you want to jump to any particular part of this. And we'll be going over to Dolly. Right on time. So here's the link for Dolly for the Wade Wilson case. And that's right, Chip. Bringing in the chicken pot pies. And also, big thank you to Gap Girl for the kind words. Kat, you do an amazing job explaining the case. Thank you for being a member. And I don't know if you guys are interested in the Wade Wilson, but we will also at 9 p.m. I'll be hanging out in Flesh of the Gods chat. That will be YSL content. I don't know what day he's going to be restreaming, but, well, I can pull the link. He might have it scheduled already. Let's see. What do we have? 9 p.m. Oh, it's a Judge Whittaker compilation of moments where Judge Whittaker, I think, ends up delivering just as much as Glanville. So this is Flesh of the Gods, if you want to hit the notification button over there, because that doesn't start until 3 hours from now. So with that being said, thanks for joining. I love these smaller, close-knit streams. It's easier for me to see what you guys are saying in the chat. So I appreciate that you guys came to hang out here today. It was awesome. And anyone going over to Dolly with us, see you there. No outro song. We're going to go right to Dolly. See you guys next time. Bye.